Unfree America. There it is. There it is. We are live. How's everybody doing today? Yes. Team DLZ in the hizzy. Listen, I'm going to give you guys a full presentation today on the cases that you absolutely must know. You must know these Supreme Court cases. I'm going to teach them in chronological order, starting in 1925, Carrol versus United States. You guys are going to have to bear with me because this live stream, I'm going to be moving my whole desk. I've got a whole setup here because I find that there's so many cases and so much information that sometimes I forget stuff because I'm going so fast. So I'm going to take my time here and I'm really going to teach you guys the 21 cases you have to know of how we lost our Fourth Amendment right in this country. And then I'm going to go through and I'm going to edit this bad chicken. I'm going to put it in vertical and then I'm going to stream it live on a loop so that people can actually learn, and they listen to it on a loop over and over and over. Eventually you'll learn the case law. How is everybody? Team DLZ in the house. You guys hit the like button if you would. Thank you for coming. I see Stomper in the chat. Fresh Toast is here. I see Jennifer Hill is in that. Nick Tate, what is going on? Playboy BTC. The other announcement I have is the hoodies are now in, my people. The hoodies are now in. We got them in stock. I have all sizes in stock. It's $50 plus $13 shipping and handling. You Venmo, Cash App, or PayPal me, and I will ship them out to you. We only have a limited amount of large and extra large, and then I have a dozen double XL, and I've got 5 or 6 triple XL. So if you guys want a hoodie, you have got to be the first to hit me up because these are going to go super quick. If you guys, on the front of it, it says, "We don't stop. We don't stop. We don't stop. We don't stop. Under any circumstances, under any conditions, we do not stop." I'm going to teach you guys some stuff today that is absolutely going to blow you away. So hoodies are in stock. Venmo, PayPal, or Cash App. It's $50 for the hoodie. Cost me $30 for the hoodie. I make $20 on each hoodie. And then the shipping is $13 to $15. So if you send me $13, $63 total, that's fine. If you want to send $65, great. Thanks. If not, that's okay too. So $50 plus $13 shipping and handling. I do have all sizes in except for small. So hit me up, and they'll put my Venmo, Cash App, and PayPal in the comment section. We don't stop, baby. Let me get rid of this hoodie real quick. Okay, so let's get into it. These are the 21 cases that you absolutely have to know, and I'm going to be extraordinarily thorough on this. I'm really going to break it down so that it's perfectly abundantly clear exactly how we lost our rights. Let me get my phone set up so I can see what you guys see. Because once I get going here, there won't be a lot of crowd interaction or me talking to anybody because I am going to take this and turn it into a vertical because we're only going to have 100 people in here right now, which is fine with me. But I'm going to put it in a vertical format so that tens of thousands of people will see it. It's just a matter of putting it in the vertical format because that's what YouTube is going to promote. There it is. There it is. I got you guys. Right on. Right on. So if you guys want to learn case law, you came to the right place today. I have been studying these specific cases for years and years, except for when we get to the 2025 case of Felix. Obviously, that holding just came out. But these are the cases how we lost our Fourth Amendment right. And you absolutely, positively have to know these cases. You have to know them. So the first one is Carrol versus United States. This case happened in 1925. The exact date of Carrol versus United States was March 2nd, 1925. And this is at the height of Prohibition. And I'll give you a little bit of the background. Drug Prohibition federal agents George Cronwet and Scully were patrolling the Detroit to Grand Rapids Highway looking for bootleggers. They had previously tried to buy liquor from George Carrol. Notice the name Carrol, George Carrol. And John Cairo, but the deal fell through, so it made them suspicious. On October 15th, 1921, the very second year that Prohibition had kicked in, they spotted Carrol's Oldsmobile on a highway and pulled it over without a warrant. They searched the car and found 68 bottles of whiskey and gin. So now, when it goes to the Supreme Court, because they had pulled them over without a warrant and with no probable cause. When it goes to the Supreme Court, they decide at the Supreme Court that they're going to create what's called the automobile exclusionary rule, that the police can warrantlessly search your car If they're in search of contraband, there's going to be a loss of life, or they're in hot pursuit. And so because of Carrol versus United States, that opened the door to completely and utterly ending our Fourth Amendment right. You lost your Fourth Amendment right because of prohibition. We only lost our rights in two ways in this country: for racism and for the prohibition of alcohol or drugs. And they have completely decimated our Fourth Amendment. Carrol is the linchpin of death. Now, on each case that we have here, Carrol sets a precedent. Now, stare decisis is the idea that the case must stand. The decision must be upheld moving forward. And a plethora of cases are going to hinge off Carrol versus United States. So more that Carrol does is it creates that exigent circumstances clause, where if they have to seize contraband, there's going to be a loss of life, or the police are in hot pursuit of you, then you don't have a Fourth Amendment right. They can warrantlessly search your car. The exigent circumstances, the three exigent circumstances, come directly from Carrol. Without Carrol, we don't have those. And this also creates the automobile exclusionary rule, where they can search your car without a warrant. How many times you've been pulled over and the cops say, I'm going to bring out and I'm going to search your car. I'm going to call out a drug dog or whatever they do. And so they search your car because of Carrol versus United States. This case is the jurisprudence for Brinegar versus United States, for Kerr versus California, and Terry versus Ohio. We're going to go over all the cases. There's 21 total cases. So Carrol, you have to know this case if you're going to understand the next case, because these cases all piggyback on top of each other. And I'm going to teach each and every one of them. So now you got to give me a second. I got to slide my whole damn desk down here. Brinegar's here. Okay. All right, there we go. Nick Tate, what's going on, bud? Good to see you. Okay, a little bit of light. Okay. So, Brinegar versus United States, this case right here, 1949. The exact date of the decision was June 27th, 1949. And this case is absolutely critical for you to understand, because you know how the cops will say we have probable cause to believe that you're committing a crime? That entire thing is based off the case of Brinegar versus United States. So federal agents stopped Virgil Brinegar near the Oklahoma-Missouri border for his reputation as a bootlegger. And they said that he exhibited suspicious behavior. They searched his car without a warrant, and they found 4 bottles of alcohol. Now, once again, without Carrol versus United States, they wouldn't have been able to search Virgil Brinegar's car, but that's what they did. And so what this does is this solidifies and upholds the automobile exclusionary rule. The court lowered the probable cause standard from requiring strong evidence to just more likely than not. Probable cause to believe. That's where that term first happens. I have probable cause to believe. That happens in 1949 in Brinegar. Now, I can't run back to the beginning of time here, but if I go all the way down this wall to 1791 when the Bill of Rights is ratified, you have a Fourth Amendment to be secure in your person, houses, papers, and effects against unreasonable searches or seizures. Well, what Brinegar does specifically is it allows them to say, we have probable cause to believe. The facts that a prudent man has in his mind of evidence he believes is against you is probable cause. And the way that it's been described over and over and over, it's like a coin flip. The cop can just decide, oh, you know what? I think there's enough probable cause here because, well, I saw you driving. There was a bootlegger's house over here. And so now I'm just going to pull you over. And this again, and done in 1949, this is about bootlegging alcohol. Prohibition has been abolished since 1933. But yet they're still trying to get people for alcohol. Then the culprit became marijuana, and then the culprit became cocaine, and then the culprit became fentanyl, and it just keeps going where the government is consistently, throughout the history of time, trying to prohibit you from getting alcohol or drugs. And what they do is they just completely decimate our Fourth Amendment. Probable cause to believe. The cop had probable cause to believe that you had something illegal in your car, and the circumstances are exigent. we believe that we have to seize this contraband out of your car before you dump it out, before you throw the crack out the window, before you dump the cocaine out the window, before you dump the fentanyl. So that means everybody is now a suspect. You're a suspect. Now, Carrol versus United States 1925, Brinegar versus United States 1949, these are the setups that are coming up for Terry versus Ohio, where they just abolish probable cause supported by oath or affirmation, and they go to reasonable articulable suspicion of the cop. Probable cause supported by oath or affirmation means that the victim of the crime that you committed from the Fourth Amendment has gone down to the police bureau, filed a complaint against you, said that you smacked my dog, raped my woman, and killed my chickens. And now you've committed probable cause sworn by oath or affirmation. Well, Brinegar versus United States completely changes that before Terry versus Ohio even happens. Brinegar says that if the cop has probable cause to believe, probable cause to believe doesn't mean anything. So what it did to the Fourth Amendment, according to the write-up here, Brinegar turned constitutional protections into a coin flip. It destroyed the rigorous probable cause standard the founders had intended, making it exponentially easier for police to justify searches and seizures based on hunches rather than evidence. That's what Brinegar does. So Brinegar then, remember, every single case has to have a case that is standing. So we go back to 1925, it happened in 1921. It's all about prohibition. Now, as we move forward to 1949, we're still trying to enforce prohibition because they only wanted to give alcohol licenses to the elites, people who had a relationship with government, with congressmen and senators. Those are the people. That's Anheuser-Busch. That family had relationships with congressmen, senators, presidents, so that they could distribute alcohol. And then they would take guys like Brinegar, Virgil Brinegar, they would arrest him and throw him in a dungeon because they had probable cause to believe and search his car. It meant that only the elites could sell alcohol, only the top 1% of people, even less. So this is how we get to where we are today. This is how we get to where we are today. So now from Brinegar versus United States in 1949, we're going to jump to Kerr versus California in 1963. The jurisprudence, the stare decisis of Carrol versus United States extends into Brinegar, then extends into Kerr. Sorry about that. Just moving around. Bear with me here. This thing will get edited down into a vertical version. Got to move my lights around a little bit. Thanks for bearing with me. You guys, make sure you hit me up for those hoodies. Those hoodies are going to go. As soon as I get off this live stream, I'll check all my text messages. Okay. So I got to kind of show two cases here at the same time. We have to recognize Mapp versus Ohio in 1961 that is going to create the warrant requirement. And the warrant requirement is going to extend into states from Mapp versus Ohio using the incorporation doctrine of the 14th Amendment. You didn't have a Fourth Amendment right in each individual state in America until Mapp versus Ohio in 1961. Well, Mapp versus Ohio... Oh, what happened? Oh, sorry, Kev. I think you accidentally got timed out. Sorry about that, Kev. I'm fixing it. There you go. You'll be back in 10 seconds, Kev. Thanks. I appreciate you guys. Got you, Mikey B. Okay, so I'm going to keep going down the line. I'm going to try to stay focused because there's a lot to cover here, and I'm going to cover everything. I'm going to cover absolutely everything. So Kerr versus California happens in 1963, 2 years after Mapp versus Ohio. And what you have to understand about this is that Mapp versus Ohio incorporated the Fourth Amendment into every different state. And this was the Warren Court. And when this was passed, the powers that be, the cops and the government, they hated Earl Warren for making that you had to have a warrant when you went into people's houses. So just 2 years later in Kerr versus California, the Warren Court gave a reprieve. And what they did was they said they created this knock and announce rule that if the cops just knock on your door and announce their presence, that they may not need a warrant. Because remember, Brinegar versus United States said that probable cause is what the officer has in his mind at the time of the infraction, that he believes the facts relevant to a prudent man in his mind. If he has probable cause to believe, then he can enter into your world bypassing your Fourth Amendment. Well, with Kerr versus California here in 1963, what this means is that the cop can say, I have probable cause to believe that criminal activity is afoot inside of this home. I'm going to knock, announce that I'm a copper, and then just come barging in your house, completely circumventing the warrant requirement that was established in Mapp versus Ohio. I mean, and this is exactly the truth. And let me read it so that you guys can understand, so that I'm 100% accurate, because there's a lot of information. The story: police suspected George Kerr of selling Mary Jane. So there's always some sort of culprit. There's always some sort of reason why, either for racism or prohibition, that the government has to create laws that circumvent our rights. Police suspected George Kerr of selling weed. Without a warrant, they used a pass key from his apartment. They went to the manager of his apartment complex and said, hey, give us the key to his apartment. The manager of the complex gave the key to George Kerr's apartment to the cops. The cops entered into his apartment, where they found him transferring Mary Jane. It was on a table, and he was putting it from a big bag to smaller bags. So the holding: the court created the knock and announce rule, requiring police to identify themselves before entering, but filled it with so many exceptions that the warrant requirement in Mapp versus Ohio became completely and utterly meaningless. It was pointless. So Mapp versus Ohio, the reason why it's not on the list of the 21 cases that I'm covering is because it's absolutely irrelevant in a lot of cases today. Now, the body camera and the cameras, your Ring camera, and your, like Kent Freeman, you having a camera in your home shows that if the cops enter your house without a warrant, that you could beat the case. But this has only been a factor since 2012, 2010 or so, when everybody got cameras in their houses. So what it did for the Fourth Amendment: Kerr was the great deception. It appeared to protect homes while actually creating a blueprint for warrantless home invasions. As long as police knock and announced, they could break down the door under countless exceptions, turning home protection into theater. This is the write-up. You lost your right to be secure in your person, houses, papers, and effects against unreasonable searches and seizures because an unelected Supreme Court wanted to give a reprieve for Mapp versus Ohio, so they passed Kerr versus California, that the cops can just come into your house by knocking first and announcing their presence. And then, of course, what's the premier factor? It's going to happen in 1968, just 5 years after Kerr, in Terry versus Ohio, where officer safety becomes paramount. So now with Kerr versus California, they can go and knock on your door, and if they say, you know what, I'm afraid he's going to come out with a gun or go grab a gun as soon as he knows there's cops outside, well, they can knock on your door and then just kick it straight down in 2 seconds flat. So there's 3 cases so far. We've gone Carrol, 1925, we've gone Brinegar, 1949, and now we've gone Kerr, 1963, which the stare decisis, let the decision stand, is going to continue in the 1968 case of Terry versus Ohio. Carrol said you don't have to have a warrant to pull a car over and search it. Brinegar said probable cause to believe in my mind whatever the crime is. Kerr said all I have to do is knock and announce. Well, those 3 cases then led up to, let's just get away with the entire probable cause standard and move to a reasonable, articulable suspicion standard. Which is going to be Terry versus Ohio. I see Let's OTVO in the chat. I see Proud American. Good to see everybody. I'm going to keep going on this. I'm going to move my lights a little bit here. So now as we get into Terry, this is where the game really changes. Terry versus Ohio is OTVO. Let's OTVO is in the chat. Everybody put in the comment section OTVO, which stands for Overturn Terry versus Ohio. Overturn Terry versus Ohio, where you live, by either ratifying your state constitution, amending your state constitution, or getting a bill passed through your House committee into the House and then into the bigger chamber of the Senate and the House, and getting that passed in Tennessee, in Kentucky, in West Virginia, in Arizona. And you can overcome Terry versus Ohio on a state-by-state basis, especially if you amend the state constitution that says that the only way you can stop someone is if there's probable cause. Because stopping people with reasonable articulable suspicion, most of the cases that you see where someone gets beat up or gets killed, they start off as a Terry stop. So Terry versus Ohio does 4 very specific things, building on the jurisprudence of Carrol versus United States, Brinegar versus United States, and Kerr versus California, building on those precedences. What Terry versus Ohio does is it does 4 specific things. Number 1, it creates the officer safety moniker, the officer safety standard, that officer safety is paramount, that anything can be done to you as long as they say it's in the name of officer safety. They can grab you, beat you, shoot you. They can do anything to you as long as they can claim in some way that officer safety was in question here. So that's the first thing Terry versus Ohio does. Second, it creates this term reasonable articulable suspicion. Reasonable articulable suspicion comes from the 1968 case of Terry versus Ohio. But what you may not know is that John Terry was arrested in 1961. In 1962, a Cuyahoga County judge named Bernard Freeman, he actually wrote Terry versus Ohio. The Supreme Court took the holding that the appellate judge wrote in Cuyahoga County, Bernard Friedman, and said, okay, that's now the standard. And what's the standard? That there's reasonable articulable suspicion. Reasonable articulable suspicion is anything the officer deems in his mind to be suspicious. Well, what exactly is suspicious? It depends on who you are. You can think something suspicious. Somebody else might not think something suspicious. So officer safety and reasonable articulable suspicion. Third, it allows police to run up and grab you and pat you down and say, I'm suspicious that you have a weapon, so I get to pat you down for a weapon. That pat down was supposed to be the back of the hands on the outside of the trouser, the back of the hands underneath of the breast coat pocket where you could have a firearm in your pants or underneath your armpit. That has now turned into a full-on POW style of arrest. Get down on your knees, lay on your belly. That's what Terry versus Ohio has created with their stop and frisk policy. And people in New York, they know it best. I try to explain to people that Terry versus Ohio is the reason why cops can grab you, and nobody knows it better than the people in New York, where the entire stop and frisk, you guys have all heard it. Put a 1 in the chat if you've heard stop and frisk. If you've heard that, that comes from Terry. In New York City, there would be no such thing as stop and frisk if there was no Terry versus Ohio. So we have officer safety, reasonable articulable suspicion, a pat down, and the fourth thing that Terry versus Ohio does is it creates this detainment clause that you can be detained. Detainment now equals, in most police departments in America, the policy of detainment means that you go in torture cuffs. That's exactly what it means. That Terry versus Ohio creates the entire torture cuff ideology. They can shackle your ankles. They can put you in the back of a caged car and strap you in. You're not yet arrested. You've only been detained. And this comes from an appellate judge named Bernard Friedman in 1962 out of Ohio. If you don't know, Ohio really didn't want black people in town. Terry versus Ohio is 100% based on racism. And I'm sorry to say it, but it's true. You don't have to believe me, but that's just the simple fact. They wanted to be able to stop the Black Panther movement. They wanted to be able to go up and grab Black Panthers and arrest them and take away their firearms. This is coupled with the 1968 Omnibus Crime Bill that came out in the 1968. What was it? The 1960. It was called the Omnibus Crime Bill, and inside of the 1960 Omnibus Crime Bill was the 1968 Gun Control Act. And so that's how we get Terry versus Ohio. Coupled with those two things, they completely ended the Black Panther movement. There was no Black Panther movement in 1969 because when black people showed up on the scene with rifles and guns to ensure their voting rights, they were summarily arrested, grabbed, patted down, disarmed, detained. That's what happened. So now we're 4 cases. Now you guys probably haven't really heard the next case very much, but it's Adams versus Williams, the 1972 case of Adams versus Williams. Let me make sure it's on my board here. Here. This case right here. I know a lot of these words run together, but you can see it. It's Adams versus Williams. It was passed on June 12th, 1972. So a lot of people will say that, they'll say, oh, you just came up and went hands-on with me. Well, let me just tell you something. For a cop to go hands-on with you, they only need a phone call. And that comes directly from the 1972 case of Adams versus Williams. Let me give you the breakdown of the story. At 2:30 a.m. in Bridgeport, Connecticut, an informant approached Sergeant John Conley and told him that Robert Williams was sitting in a nearby car with narcotics and a gun on his waist. Detective Conley approached the car and asked Williams to open the door. When Williams rolled down the window instead of opening the door, Conley reached in and removed a pistol from Williams' waistband, exactly where the informant said it would be. So what this holding does is it extended Terry stops to allow searches based on anonymous tips from unidentified informants with no corroborating information. So all someone has to do is call the police on you and say, hey, that guy has narcotics and a gun on him, and the police can run up and grab you. Remember, this is an extension of Terry, which is an extension of Kerr, which is an extension of Brinegar, which is an extension of Carrol. Without Carrol versus United States, there's no way possible for Terry versus Ohio. Each case piggybacks on the next, and each case infringes on our Fourth Amendment right a little bit more and a little bit more and a little bit more. Let me keep reading here. So what it did to the Fourth Amendment is Adams took Terry versus Ohio's reasonable articulable suspicion and it made it even more tyrannical by allowing anonymous accusations to strip away your constitutional rights. It established that any random person could call the police and destroy your Fourth Amendment protection without any verification that it's a reality, that anything they're saying is true. It turned hearsay into probable cause and anonymous tips into reasonable suspicion. So you understand that? If I call the cops on Terry Marine bad mofo and I say Terry Marine bad mofo has got a gun and got narcotics, well, now that's just hearsay. I'm just saying it. But now the cop can run up and grab him. And this was 72. This is in 1972. So we're not even talking about 2025 standards of cops are all terrified. They've been trained now since 1968 to be afraid for their lives. And all they have to do is say, I feared for my life. And then the cops can do anything they want to you. So if you want to know, yeah. So that was in 1972. Now, the infringement into your Fourth Amendment just continues to go down, down the tubes. And so if they could grab you and they could search you and they could detain you, well, then the next step, obviously, is going to be that they can search your entire person as soon as they grab you. So that's the 1973 case of Robinson versus United States, where the Supreme Court said that they can just grab you and search every part of you with search incident to arrest. Which is here. The 1973 case of United States versus Robinson. Let me give you guys a little bit of the background. Let me fix my lighting a little bit. I'm going to cut this bad chicken into a vertical, and I'm going to play it on vertical on a loop so that people, because tens of thousands of people will watch the vertical stream, and we only may have 100 here, but eventually somebody will see this and they're going to learn something. And then I'm going to be so grateful that more people put OTVO in the comment section. It should actually be overturned Carrol versus United States, because none of these cases are possible without Carrol. So now let me give you guys a little bit of background on the 1973 case decided December 11th, 1973, United States versus Robinson. So Officer Robert Jenks stopped Willie Robinson for driving with a revoked license, a crime punishable by only a fine in the District of Columbia. After arresting Robinson for this minor traffic violation, Jenks conducted a full search of Robinson's person and found a crumpled up cigarette packet in his pocket. And inside of the packet of cigarettes, he found 14 capsules of heroin. The holding. The court ruled that police can conduct a full warrantless search of any person immediately upon arrest for any crime. No matter how minor, without any evidence, the person is armed or hiding evidence, they can search you. All they have to say is that you're under arrest. So what it did to the Fourth Amendment, Robinson turned every arrest into a fishing expedition. It didn't matter if you were arrested for jaywalking, unpaid parking tickets, or minor violations. Police gained the power to search your entire person, clothing, immediately around you for anything illegal. United States versus Robinson destroyed the principle that searches must be related to the crime or officer safety, instead giving police unlimited search power triggered by any arrest, turning minor violations into constitutional violations by the cops. So the entire idea that you can be searched, search incident to arrest, comes from the 1973 case of United States versus Robinson. And oh, by the way, Robinson was black. And half of the tyrannical Supreme Court holdings in America are done because the defendant was black. And they had a very specific agenda to stop the Black Panther movement and not allow black people to be able to resist against the government. And this is just plain simple fact. You don't have to like it, but it's 100% true. So now, if the cop arrests you from the 1973 case of United States versus Robinson, then the cops can immediately search you. So now all the cop has to say is you crossed the street illegally, you're under arrest, and now I'm going to search you. And say that you have a pair of pants that you have your ADHD medication in, you have your Adderall pill, or say that you have a high blood pressure pill in your pocket because you don't want to take the whole bottle. They find that one high blood pressure pill. I have high blood pressure pills. And they say, oh, I don't know what this is. And you say, that's my high blood pressure pill. Give it to me. I'll take it. And they say, oh, no, I can't. It's contraband. And that's what United States versus Robinson did. All they have to say is you're under arrest and they can search you. And if they search you, they can find something and say, oh, you must be doing something illegal with this. It couldn't be your ADHD medication. It couldn't be your high blood pressure medication. It couldn't be something for your diabetes. It has to be that it's a crime. And that's what we're living under right now. So then from the 1973 case of United States versus Robinson, we're going to have Brigoni Ponce, which is going to be 1975. Brignani, right here. Here's the case of Brignani Ponce. So this is a further infringement into your Fourth Amendment rights right here. So if you guys didn't understand Supreme Court, how we lost our Fourth Amendment, this is really, really going to help you understand how we lost our Fourth Amendment right. Brignani Ponce. And this case was slightly altered this year where they changed some essential things here. And let me get into it here. Let me see what the write-up is. Brignani Ponce. This is where the Supreme Court said, let's see if I can find it again. This is where the Supreme Court said, let me give you the story behind this, and I'm just going to read it so that way it's 100% clear and I can't mess it up because there's so much information to cover here. There really is. If you really want to understand how we got here, you have to understand each and every one of these cases. So Border Patrol agents in Arizona noticed an unusual footprint pattern in the desert and vehicle tracks that suggested human smuggling. They staked out the area and stopped a vehicle. Nope, that's not it. Okay. It's the same thing, but it wasn't in Arizona. It was in San Clemente, California. That's how I knew right away when I was reading the story that it's not true. I know that Brignoni Ponce happened in California and Cortez versus United States happened in Arizona. So let me go back to Brignoni Ponce. Border Patrol agents Felix Brignoni Ponce and another agent were stationed at Interstate 5 near San Clemente, California, approximately 65 miles north of the Mexican border. And doesn't that just chap your ass? When the cops stop you, when the Border Patrol stops you 65 miles north of the Mexican border, they were conducting roving patrols looking for illegal aliens when they spotted a car with 3 occupants who appeared to be of Mexican descent. Brignoni Ponce here. The agents stopped the car for no other Mexican and were illegal immigrants. So the holding is that the Supreme Court ruled that border agents can stop vehicles near international borders based solely on the apparent Mexican ancestry of the occupants. The court created the Mexican appearance factor as sufficient reasonable suspicion for detention within border zones. So what it did to the Fourth Amendment is it allowed racial profiling. It created a constitutionally acceptable basis for police to stop people, essentially codifying discrimination into the Fourth Amendment. It created constitution-free zones. It established that within 100 miles of the international border, covering 2/3 of the United States, normal Fourth Amendment protections don't apply. This is the case that created that 100-mile border area. You guys have heard of that before. How many of you guys, put a 1 in the chat if you guys have heard of that, where within 100 miles, and they did the same thing with the National Defense Authorization Act, also known as the Patriot Act, where they used the Brignoni Ponce holding to say anywhere within 100 miles of the border, we can now, that's a constitution-free zone. because you're within 100 miles of an international border. We have to push back against that. And the states would be Texas, Arizona, California, New Mexico, any states that we're going to border Mexico. We have to make sure that we get rid of this 100-mile zone. It expanded police state geography. It gave Border Patrol sweeping power to stop anyone in a massive swath of American territory. 2/3 of American territory can now be searched by Border Patrol agents, and all they have to say is that I think the Mexicans in your car are illegal immigrants. This normalized mass surveillance. It authorized roving patrols that could stop vehicles based purely on the demographics of the occupants. The racial demographic. Because Brignani-Ponce essentially created a second-class citizenship based on your appearance if you look like you're Mexican or brown. I think eventually, collectively, if you guys don't know the cases that have to be overturned and the U.S. population is ignorant as to what has to happen, I think that we're going to find ourselves in a very precarious position as we are now. Now, this government is trying to regulate what's called hate speech. I'm not really sure exactly what that is. I don't know what hate speech is. Saying I hate you? I don't really understand how hate speech is. I don't understand what it is. I don't know what it is. I can't define what hate speech is. It's a load of crock. It's a way to curb your speech. So this is Fourth Amendment jurisprudence. We're going to do a First Amendment one tomorrow or the next day, and then I'll cut it into a vertical so that people will watch it. Because, as you guys know, when I stream in horizontal, a lot of people don't even get notified. Tomorrow, when I cut this into vertical, there'll be thousands of people who say, man, I didn't even know you made videos anymore. I sure do. I still make videos. Oh, okay. So it looks like that light's going to run out. So now we're going to go to the 1981 case of Cortez versus United States. Illinois versus Gates is next. But United States versus Cortez here, January 21st, 1981. There's so many cases on here, I apologize, but this is the case we're going to be discussing next. So what Cortez versus United States is it starts the give me 1 second. Let me read you the whole story of Cortez versus United States so that I don't make any mistakes on it and it's 100% clear. Cortez versus United States, 1981, here. Let me jump on this side maybe. There we go. That's a little bit better because now we can see where United States versus Cortez is right here. And let me give you the absolute facts of this. Border agents in Arizona noticed unusual footprints in the desert and tracks that suggested that someone could be bringing over illegal immigrants across the border. And so the fact that it matched their theory of when smugglers operate with the footprints at night and the tire tracks at night, none of these factors were suspicious alone, but when you took the totality of circumstances, then Cortez became a real thing. So what the holding does, the court created the totality of circumstances test for reasonable suspicion, allowing police to combine multiple innocent behaviors, multiple innocent factors to create the totality of circumstances, and using the Terry doctrine of detainment, they could then detain those people. And as you know, detainment often means today torture cuffs, and torture cuffs are always torture. TCAT, put it in the chat. TCAAT, torture cuffs are always torture. Put it in the chat for me, pretty please, with sugar and cherries on top. So what it did to the Fourth Amendment, Cortez criminalized normal behavior by allowing police to turn innocent acts into suspicious conduct when viewed together. It gave cops the power to create reasonable suspicion by combining perfectly legal activities, driving at night, being in certain areas, driving certain kinds of vehicles, and claiming that the combination of driving at night, having brown skin in your car, driving in a van, that then equaled reasonable articulable suspicion, which is the Terry factors, which then they can stop you in the name of officer safety, grab you, and then in the name of officer safety, detain you. So that's what it did. That's the Cortez versus United States. it starts the totality of circumstances. And totality of circumstances is going to be horrific for all of us because, so in 1969, there's a case called Aguilar-Spinelli. And the 1969 case of Aguilar-Spinelli talked about confidential informants, where if a confidential informant gives police a tip about you, information about you, that Aguilar-Spinelli factor created the two-prong effect, where the cops had to, they had a right to investigate the information, but they also had to look into the confidential informant and see if that person had any sort of axe to grind with you. You're a painter across the street. I'm a painter on this side of the street. I'm going to tell the cops that you're a drug dealer, so the cops will then arrest you, so then I can go across the street and say, hey, I'll finish that contract for you guys. And so the Aguilar-Spinelli case from 1969 is going to get upended by the 1981 case of Cortez versus United States because it's going to create the totality of circumstances clause. Now, the totality of circumstances clause is going to extend into the 1983 case of Illinois versus Gates. Now, if you guys don't know, Illinois versus Gates is how I was wrongfully arrested and wrongfully charged. The reason why I absolutely loathe police, the reason why I have such a problem with cops and the policy, procedure, and protocols of police is because the 1983 case of Illinois versus Gates. Let me read the exact holding because this was, in case you guys don't know, what got me going down the line to discover Terry versus Ohio was in my own charges against me in the early 2000s when I was innocent and I was found not guilty of the charges they put against me. But Illinois versus Gates, let me read it for you exactly. Police received an anonymous letter claiming that Lance and Susan Gates were selling drugs with specific details about their travel patterns between Illinois and Florida. The letter provided no verifiable information about the tipster's reliability or how they knew the information. Based solely on this anonymous tip and some surveillance confirming the couple traveled, police got a search warrant. So remember, somebody called in on the Gates and said, we have information about these people, but the police never verified any of it. They just took it at face value and said, oh, it must be true. So the holding, the court destroyed the rigid two-prong test of Aguilar-Spinelli for informant's reliability and replaced it with the vague totality of circumstances standard for search warrants. What it did to the Fourth Amendment, Gates turned the warrant process into a rubber stamp by eliminating requirements that informants be credible or their information be verified. It made it exponentially easier for police to get search warrants based on unreliable sources, stale information, and uncorroborated tips, essentially allowing judges to approve search warrants based on police speculation rather than reliability of the evidence. So now let's go back and let's trace back the progression here. Let's trace back the progression of what we've learned so far. Carrol versus United States creates an exception for a warrant. Brinegar versus United States, 1949, creates probable cause as whatever the officer believes in his mind. Probable cause to believe. So in other words, they can just say they believe there's probable cause, and there is. Then after Brinegar versus United States in 1949, you get Kerr versus California, which is the knock and announce rule. I can just knock, 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 announce my presence and come walking in because from Brinegar, I believe there's criminal activity afoot. I don't have time to get a warrant because the exigent circumstances clause of Carrol versus United States, there's going to be a loss of life. You're going to get rid of the evidence, contraband, or I'm in hot pursuit of you. So now using Brinegar and Carrol in Kerr, I'm just going to knock, announce, to come running in. Now, up to 1968, you're going to get Terry versus Ohio that's going to create that reasonable articulable suspicion standard instead of probable cause supported by oath or affirmation. That reasonable articulable suspicion in 68 is going to carry forward in the 1972 case of Adams versus Williams, where now reasonable articulable suspicion is equal to an anonymous tip. Someone just calls me up and says, hey, I think that Letzo TVO has a gun and heroin, so now I can just run up and grab him. 1972 case is going to extend to the 1975 case of Brignani-Ponce, where they create a 100-mile border area all around the United States, which really encompasses 2/3 of the United States. And Brignani-Ponce is going to say that we can be reasonably articulately suspicious of you because of your skin color. It's just going downhill from here. 1973, United States versus Robinson says that if I arrest you, search incident to arrest, I can search your person and anything around you. That's not going to change until the Chille rule, and then the 81 case of New York versus Belton, all the way up to the 2009 case of Arizona versus Gaunt. But we're going to stay on Fourth Amendment jurisprudence here. From that 1973 case of Robinson and the 1975 case of Brignani-Ponce, we're going to move up to the 1981 case of Cortez versus United States. They're going to say they can take the totality of circumstances. We saw tire tracks in the sand. We saw boot prints here from more than one person. So we're going to take all these things and we're going to create reasonable articulable suspicion, which then is going to extend into the 1983 case of Illinois versus Gates. Illinois versus Gates is now going to wipe away the fact that you have to actually verify the confidential informant's information from 1972 and the Aguilar-Spinelli case of 1969. And what's going to happen in the 83 case of Illinois versus Gates is they're going to say, hey, look, we got a tip. And so we're going to act on that tip because it made us reasonably articulably suspicious. And so this is what happened to me in 2002. A confidential informant told Chief of Police Michael Moore of the Los Angeles Police Department that I was a drug dealer. With no other information, they SWAT raided my house. Now, when I eventually took a plea deal for a simple possession of what was a bodybuilder's chemical and only an amount that I could just use for myself, meaning that I was never convicted of being a drug dealer, it didn't stick. There was no merit to it. But they took the word of a confidential informant from the 1983 case of Illinois versus Gates. They then watched me traveling, took pictures of me, followed me around, and because I was an actor and I drove a sports car, they then said, oh, well, he must be a drug dealer. All he does is go to auditions and drive a sports car, so he must be a drug dealer. They kicked down my door, and of course, I'm not a drug dealer, and I never was. So they couldn't find any evidence of that, so eventually it was reduced down to a simple possession charge. Which, by the way, the chemical that I was doing was legal in 2001, became illegal in January 1st of 2002. And 100% I was using the chemical for your body because it was healthy. So this is how I got to being what I would consider one of the foremost voices on Terry versus Ohio, because the 1983 case of Illinois versus Gates is not possible without the reasonable articulable suspicion standard of Terry versus Ohio, which dramatically lowers down our Fourth Amendment right to be secure in our person, houses, papers, and effects against unreasonable searches and seizures, and no warrant shall issue but upon probable cause supported by oath or affirmation of the victim that you have committed a crime against. And this is how I got to where I am today. It was all because of the 1983 case of Illinois versus Gates, where a confidential informant told the police that I was a drug dealer, and it'll come out in my book. I'll tell you who did that, who I believe did that, and the reason why they did it. And I'll go into great detail in my book. So hopefully I'll have it done. But let's keep going. So now, this just to recap real quick, because I went on a personal story about myself. Illinois versus Gates wipes away any probable cause standard and says reasonable articulable suspicion is whatever the informant told us. Whether the informant has an axe to grind or is reliable or it's false information doesn't matter. Illinois versus Gates allows you to call the police and say, I'm suspicious that what's the matter, you is a drug dealer, or he's a rapist, or he's a murderer, and then the police will have to investigate him because they're reasonably articulably suspicious. Illinois versus Gates is the absolute, one of the worst cases. Okay, so now we're going to move down the line here a little bit. And this is kind of where it gets a little bit dirty. It gets where the lines of what is right and what is wrong become very blurred here. And that's going to be the 1985 case of Tennessee versus Garner, which should be right here. Okay, cool. So I don't even have to move this bad chicken. I can move it just a little bit. Okay, so Tennessee versus Garner is a specifically disturbing case. And the reason why it's specifically disturbing is because Tennessee versus Garner is one of these nothing burger cases here. Tennessee versus Garner was decided March 27th, 1985. And what it's supposed to do, so let me give you a little bit of background. The model penal code was written from 1952 until 1962. I believe it was Waxler or Waxman is one of the chief authors of the Model Penal Code, and I believe that Harry Blackmun was a contributor to the Model Penal Code from 1952 to 1962. Now, when black people were freed in 1954, they had to stop and redraft the Model Penal Code in 1954 after Brown versus Board of Education. Even though blacks are not going to be freed until the 1968 case of Green versus New Kent County, when Supreme Court Justice and KKK member Hugo Black said that, no, you have to desegregate now. But from 1954, it was desegregate with all due factors, with all due relevance, desegregate. So when we get to Tennessee versus Garner, there are so many things that have happened. The Model Penal Code, written from 1952 to 1962, what it said is they used what's called the fleeing felon the fleeing felon theory, the fleeing felon clause, the fleeing felon fact. So back in the day when we left England and the Revolutionary War happened, there was the fleeing felon clause that said that if you fled from authorities, that the police could kill you. They could kill you. And so from 1952 to 1962, that's actually codified into federal law, and it's codified by a lot of the states that the fleeing felony clause is a real thing, that if you run from the police, they can shoot you and kill you, and that's perfectly fine. So now that's written in the Model Penal Code, and it's important that you know that, because I believe that Harry Blackmun was one of the authors of the Model Penal Code. And the ironic part is that when Tennessee versus Garner goes to the Supreme Court in 1985, Harry Blackmun is on the Supreme Court, which is ironic that he had upheld the fleeing felon clause. But then in the 1985 case of Tennessee versus Garner, Eugene Garner, like Eric Garner, I guess you would say, Eugene Garner is shot in the back of the head in 1974, the year I was born, when he had gone to his neighbor's house and took a $10 bill off the coffee table and then fled the house. Well, then when the cops came over to the house, they saw him in his own backyard. So the cop went into his own backyard to go say, hey, Eugene, I got to talk to you. Eugene Garner is a 14-year-old black boy. So then Eugene Garner runs away from the cop. I believe his name was Turek. Let me see. And when he goes to jump the fence, Eugene Garner, that cop shoots Eugene Garner in the back of the head with a hollow tip bullet. It goes out the front of his head, splits his head open like a watermelon. And so from 1974 until 1985, Eugene Garner's parents are trying to get justice for him being murdered in his own backyard for stealing a $10 bill off of his neighbor's coffee table, which I believe he was guilty of, according to some of the court records. So now what happens is in 1985, the holding goes in favor of the Garners, and they say that the fleeing felon clause that comes from the Model Penal Code is actually unconstitutional, and police cannot shoot you when you run away from them unless it's in the name of officer safety from Terry versus Ohio, or the community caretaking. They have community caretaking responsibilities that you can't shoot a fleeing felon unless they're going to be a danger to the community or it's for officer safety. So Tennessee versus Garner is one of those cases that's an absolute nothing burger, that the cop can shoot you if you run away just by saying, I thought he had a gun. And then, as you know, if that cop shoots you when you're running away and says, oh, I think he had a gun, then what happens? It goes to court and they say, well, a prudent man would believe he had a gun because someone said he had a gun, so we have a witness testimony, and then he was running away. He reached his hand in his front like this, so I thought he had a gun, so I shot him in the back of the head. Then, even if the cop is convicted, he's not convicted of murder. He's convicted of manslaughter, meaning he'll do 1 to 5, 1 to 6 years in prison. He'll get out at the most if he does any prison time. The jury may recommend no prison time and probation, and he loses his job. But Tennessee versus Garner is a nothing burger case where your life you could be shot in the back by a cop, and all he has to say is it was in the name of community safety or in the name of officer safety. Terry versus Ohio is prevalent and relevant in Tennessee versus Garner. Tennessee versus Garner is not possible without Terry versus Ohio. Terry versus Ohio is not possible without Carrol versus United States. You see how each one of the cases, when you go back, why was Carrol versus United States passed? In the name of prohibition. We absolutely have to stop this evil alcohol. And they did the same thing through the 70s and the 80s for Mary Jane. Carrol versus United States then extends into Kerr versus California in 1963. Now it's not alcohol that's the culprit. It's Mary Jane that's the culprit. We have to shut down this Mary Jane. It's making people go crazy and jump off buildings and hatchet their parents to death. That was the propaganda that they sold us all through the 40s and 50s. By the time you get to the 1963, remember that the single convention on narcotics drugs is held in 1961 in New York City, led by Harry Anslinger, where he brings over every single diplomat from every westernized country in the world at that 1961 single convention on narcotics drugs. And Harry Anslinger convinces them that marijuana will make your kid turn into an axe murderer. It'll make your mother jump out the window. And this 1961 single convention on narcotics drugs has a huge effect on the 1963 case of Kerr versus California, where they create the knock and announce rule. They can just knock and come right in. Kerr versus California is going to extend into Terry versus Ohio in 68, reasonable articulable suspicion. Reasonable articulable suspicion is going to expand even further to totalitarian circumstances in the 1983 case of Illinois versus Gates. And then when we get to Tennessee versus Garner, the fleeing felon clause of the model penal code from 1952 to 1962 is now overturned, and you cannot shoot a fleeing felon as they run away unless it's in the name of officer safety or community safety. So it's a nothing burger case. It means absolutely nothing. The Garners won, but they didn't get anything. And as a matter of fact, the holding is so vague and so open that you can shoot anybody you want when they run away. You just have to say that you had officer safety fear for your life. He was running away, but I was afraid, which is going to extend into the 1995 case of Wilson versus Arkansas. But we have a case after that, which is the 1989 case of Graham versus Connor and Sokolow. So we have two cases in 1989 before we get to the 1995 case. Let me roll this bad chicken back a little bit. There it is right there. It's up there. So I'm going to have to it's above my head. Let me just get my lighting right here. Thank you for bearing with me. Good to see you, Team DLZ. Thanks everybody for coming. I really appreciate it. Thanks for coming. You guys hit the like button. Make sure you're subscribed to the channel. When this goes out in vertical, it's going to be great because, you know, hundreds of thousands of people will see it. I just have to edit it into a vertical stream. What's going on, BS Unleashed? Dan Fizzles in the... What's going on, Cope Doggy Dog? I see you, man. Yeah, I sure would like to get into that. Death Angel, what's going on? Oh, is that right? You got blocked out? Sorry to hear that. Okay, let's keep going. And I'll edit out this little crosstalk in the vertical version. Hopefully I have the vertical version done by tomorrow. We're going to get into Barnes versus Felix, eye for eye. Barnes versus Felix is 2025. Right now, we're at the 1989 case of Graham versus Connor right here. So I'm going to do the reading on Graham versus Connor that they have here, but then I'm going to explain it in layman's terms so that you can understand what Graham versus Connor does to you and what actually happens on the street. Because remember, the words that they put on the screen for the holding or what the court said or what the actual standard is, that's not true. The actual standard is whatever happens on the streets that the cops can get away with, which is why Terry versus Ohio is the most liberty stripping holding in the history of our country, besides maybe Dred Scott. But Dred Scott was eventually overturned because of the 13th, 14th, and 15th Amendment. But let's get into it a little bit. I'm going to read the story here. DeThorne Graham here, this case right here, Graham versus Connor, I believe it says May 15th, 1989. DeThorne Graham is a diabetic. He felt an insulin reaction coming on and asked his friend William Berry to drive him to a convenience store to buy an orange juice. At the store, Graham saw a long line and quickly left and asked Berry to drive him to a friend's house instead where he could get some sugar in his system. As they were driving, Officer Connor, who'd been watching them, he thought that their behavior going into the Quickie Mart and running back out, he thought that behavior was suspicious. He invoked Terry. He then pulled over Barry, the driver of the car, based on his reasonable articulable suspicion that two black guys had just gone into a convenience store and then ran back out, so they were probably casing the joint to rob it. So he pulls over Barry, and then he beats the holy hell out of Graham. He cuffs him. He breaks his ribs. He cracks his head. He breaks his foot. The cop in Graham versus Connor, DeThorne Graham, Connor is a son of a gun. He breaks the bones of DeThorne Graham. So then they shove him face down on the hood of the police cruiser. And even though he's trying to explain a situation, he shows Connor his diabetic card. He doesn't care. Instead, Graham sustained multiple injuries, a broken foot, cracked ribs, cracked head. And then what they do is they then throw him in the back of a patrol car, take him to his house, and drop him off at his house. So, of course, then Graham sues for his rights being violated, the holding. The court established what's called objective reasonableness, a standard for all excessive force claims. Remember, this is done against a black guy, and now all excessive force claims are based on Graham versus Connor from 1989. So if you got roughed up and beat up by the police, remember, objective reasonableness is created because the cops have to have something to say when they beat up black people. Whether I like it or not, that is the truth. That is 100% the truth. So the court establishes objective reasonableness, and the excessive force claims must be judged. Get this. This is the worst part. Excessive force claims ruled that it must be judged from the perspective of the reasonable officer on the scene. So when you take your excessive force charge to the courts have to view it from the reasonable officer on the scene, that he used objectively reasonable force. So what it did to the Fourth Amendment, Graham was the master key that unlocked police immunity from accountability. It created a reasonable officer fiction that shields police from consequences by requiring courts to judge brutality from the cop's perspective rather than the victim's reality. Graham eliminated consideration of officer intent, meaning police can torture citizens as long as they claim they were being objectively reasonable. It turned the Fourth Amendment into a protection for police rather than for citizens, making police the judges of their own context. So Graham versus Connor absolutely has decimated your right for excessive claims, because the excessive force claim must be judged from the perspective of the reasonable officer on the scene. That's what Graham versus Connor actually does. Oh, yeah, I hate that guy too, Pat Lynch. He's such a piece of shit. Such a piece of shit. Okay, so now let's do a little bit of a recap. Graham versus Connor is above my head. You can barely see it. But I want to do a little bit of a recap of Graham versus Connor plus Terry versus Ohio. So we get that you don't need a warrant, and there's exigent circumstances from Carrol versus United States in 1925. Now, once we've infringed in that Fourth Amendment, you're going to jump forward to the 1968 case of Terry versus Ohio. Terry versus Ohio gets rid of that probable cause standard and lowers it down to reasonable articulable suspicion. It also introduces the term reasonable articulable suspicion. Now, everything is going to hinge on that word reasonableness of the Fourth Amendment. Officer safety is the paramount number one factor when you have an interaction with police, that their safety comes first. Officer safety first. That comes from Terry versus Ohio. So now when you couple Terry versus Ohio plus Graham versus Connor, what you get is the cops can walk up to you based on their suspicion. Now, in the name of officer safety, they can grab you and put you into a POW style of arrest and detain you. If you say, hey, look, I don't want to be detained, don't put your hands on me, the cop can then say, my objective reasonableness, I believed that previously to my interaction with him, he had robbed a convenience store with a gun. So because I believed that he had robbed the convenience store with a gun, and then when I walked up to him and told him to turn around and bend over, because that's what Terry versus Ohio allows cops to do, the Graham factor then kicks in, that I can use the objective amount of reasonable force that I feel is appropriate for the scene. Which, if I believe that you had just robbed a liquor store and you had a gun, then that's going to factor into my decision-making process. And my decision-making process now says that if you don't do what I say, I'm immediately going to go hands-on, nightstick, firearm, taser. And so when you have Terry versus Ohio plus Graham versus Connor, that equals a death sentence. Cop can see you across the parking lot, decide he's reasonably articulately suspicious of you, run up to you and say, turn around and bend over, put your hands on the wall and stick your ass out, break yourself like you're a little bitch. Then the cop can put his hands all over you, put your hands behind your back and torture cuff you. And if you resist in any way, he's going to tell the jury that he was sure that you were the guy that robbed that liquor store. And he was sure that you had a gun, so he used objective reasonableness. The court holding in Graham versus Connor says that It must be seen from the objectively reasonable officer on the scene. Terry v. Ohio plus Graham versus Connor equals a death sentence for you. You didn't comply, and all the bootlickers will watch it and say, you didn't comply. It's your fault that you didn't comply. Which is going to lead us to the 1989 case of Sokolow, which I did put another Sokolow on the board here, so it's a little bit lower. I don't have to move the scene at all. So I know Sokolow inside and out, but what I'm going to do is I'm going to read it, so that way I don't give any sort of distorted version of Sokolow, but Sokolow is a disgusting case. Sokolow versus United States, 1989. Let me read it, and then I'll give you the actual layman's terms of it, because Graham versus Connor, it gives you these kind of stale words like objective reasonableness, and it's seen by the perspective of the reasonable officer on the scene. When you read it, it makes a lot of sense. When you apply it in real life, Terry versus Ohio plus Graham versus Connor, you get death. So I'll read Sokolow to you, and then I'll tell you what the actual application of Sokolow is. Andrew Sokolow flew from Honolulu, Hawaii to Miami and back in 48 hours, traveling under the assumed name, paying $2,100 in cash for his tickets and carrying only a small carry-on for the long trip. The DEA agents at the Honolulu airport thought that this fit their description of what a drug courier profile is. Well, let me just say something. In today's world, you can't be traveling and using a fake name. That doesn't work. I don't know how he was able to travel with a fake name back in 1984. The case was heard in 1989, but Andrew Sokolow did exactly that. So the DEA agents then said that's a drug courier profile because of his travel patterns. He's traveling from Miami to Hawaii. He doesn't have any luggage just to carry on, and he used a fake name. Well, of course that's going to be suspicious. But that drug courier profile is the main thing that you want to pay attention to when you're looking at Sokolow versus United States 1989. So they search him and they find 1,000 grams of blow in his carry-on. So the holding. The court ruled that police can stop and detain citizens based on drug courier profiles. A list of behaviors and characteristics that supposedly indicate drug trafficking, even when each individual behavior is perfectly legal. So now, how did we get here? So Sokolow criminalized being poor, traveling using cash, and creating discriminatory policing policies based on appearance and economic status. It legalized stopping citizens for paying with cash. You buy your ticket in cash, that could be a trigger to stop you. If you appear nervous, if you fit the description of somebody, Sokolow essentially made constitutional rights dependent on how you look, where you travel, how you pay, and if you don't have any money. If you're a minority and you have brown skin. And cash transactions now became reasonable articulable suspicion. So how do we get here? How do we get to this point of Sokolow where they can create a drug courier profile on you based on absolutely nothing? We go Carrol versus United States, where they infringe on your Fourth Amendment. Then you have Terry versus Ohio, 1968. And then you have Illinois versus Gates, which creates the totality of circumstances. Now, taking those four cases previously, we can say that Dan Hanlon is traveling using cash. His skin is brown. He doesn't have enough luggage. He doesn't look like he's kept up. You're just taking random things and putting them together. But Sokolow goes a lot further than that. So when they say that they can create a drug courier profile on you, specifically what that means is that when you get pulled over now, the reason why the cops ask you, hey, where are you coming from? And where are you heading? Because with those two questions, what that does is if you answer those questions, instead of invoking your Fifth Amendment right, using the trifold, the reason why I put all these cases on the trifold, instead of you invoking your Fifth Amendment right, if you tell the copper where you're coming and where you're going, the cop can then say, based on my training and experience, which Sokolow invokes, that the Supreme Court said that a cop can rely on his training and experience, and the training and experience is testimonial fact. That the cops can say, my training and experience tells me that because Dan Hanlon is going from Albuquerque to Austin and he doesn't have a lot of bags and he looks a little disheveled and he paid with cash, now Dan Hanlon can be pulled off to the side and he can be searched based on patting you down, Terry versus Ohio. And then because of officer safety, they have to look in your bag because they're afraid you could have a weapon. It's just, It's a doorway to tyranny, which is the state that we're living in today, where the cops can grab you, stop you, throw you on the ground, put you in cuffs, put you in a cage, and you haven't been arrested because the Supreme Court said so. So this is a reminder to everybody. The Socolow case allows them to create a drug courier profile on you. That drug courier profile is enacted when he says, where are you coming from? And you say, I'm coming from 123 Main Street. And he says, where are you going? And you say, I'm going to 555 Johnson. Now the cop says, well, my training experience tells me that anybody coming from here and going to here, that's a drug courier. So I created a drug courier profile on you, meaning now I can detain you, put you in torture cuffs. Now I can call a drug dog out because I have reasonable articulable suspicion. That's going to upend the 2018 case of Rodriguez versus United States that says that the cops cannot call a drug dog out unless they have reasonable articulable suspicion. Well, if you answer those questions, where are you coming from and where are you going, then the cop says, based on my training and experience, that tells me he could be a drug courier. So now you can't stop them from calling a drug dog out. And when it goes to court, if they find a roach in your car, they search your whole car, they find a roach. Now you happen to be in South Carolina or in North Carolina where it's completely illegal. Now you get arrested and charged, and it's perfectly legal because you told them where you're coming from and where you're going. This is the whole point of Socolow, so that they could create drug courier profiles on everybody. And these are the facts. These are the facts. It gets even worse. So now we're in 1989. A little recap here. We went from Carrol, 1925, to Brinegar, 1949, to Kerr, 1963, to Terry versus Ohio, 1968, to Adams versus Williams, 1972, to Brignani-Ponce in 1975, United States versus Robinson, 1973. They can search everything on your person. The 1981 case of Cortez versus United States, the introduction of totality of circumstances. The 1983 case of Illinois versus Gates, where totality of circumstances becomes a legitimate legal thing, which wipes out the 1969 case of Aguilar-Spinelli. 1981 case then extends to the 1985 case of Tennessee versus Garner, that based on the fleeing felon clause, they can still shoot you in the back as you run away, as long as they invoke the 1968 case of Terry versus Ohio, that they had fear for officer safety. The 1985 case of Tennessee versus Garner is then extended into the 1989 case of Graham versus Connor, that says the cop can use objectively reasonable force. Because remember, 85 Tennessee versus Garner says cops can't shoot you when you run away unless it's in the name of community safety or officer safety. So then just 4 years later in Graham versus Connor, they say, well, we want to expand that a little bit and say that it's objectively reasonable for the cop to shoot you in the back of the head. He's going to base his reasoning on the idea that what you did before this incident and what he thinks you're capable of doing to him. And the court has to judge it from the perspective of the reasonable officer. Are you seeing a pattern here? How the court is consistently leaning towards the cops and giving the cops all of our rights? That's what's happening. All right. So then as we continue down the line, we're going to get the 1990 case of Michigan versus Sitz. 1990 case of Sitz versus Michigan State Police. And I believe it's going to be... Oh, I did not put it on the board. So the 1990 case, let me put the lights here so you guys, hopefully when I cut this into a vertical, it cuts together super well, but we shall see. Remember, I got hoodies in, you guys. Hoodies, $50 plus $13 shipping. I make $20, cost me $30 per hoodie to produce. I make $20 and you guys pay for the shipping, which is $13. I have all sizes in except for small. I don't have medium either. I have large, extra large, double XL, and triple XL. So let me know. Okay, cool. So now we're going to continue the line. The 1990 case of Sitz versus Michigan State Police. I have to have put that on the wall. It really, I can't believe it's not on the wall. I'll superimpose it in post when I put it into vertical. So the 1990 case of Sitz versus Michigan State Police, let me read it to you because I don't want to give you any sort of biased perspective that I have because it's tyrannical. It expands on the Suarez case of 1967 that's going to create the checkpoints where they can ask you questions. So Michigan versus Sitz, the Michigan State Police established a sobriety checkpoint program where they would stop every vehicle or every nth vehicle at predetermined locations to check for drunk drivers. During a 75-minute operation, they stopped 126 vehicles and arrested 2 drivers for drunk driving. Rick Sitz and other drivers challenged the program, arguing that stopping every motorist without individualized suspicion, Terry versus Ohio, violated the Fourth Amendment. Well, the holding was the court ruled that sobriety checkpoints are constitutional, allowing police to stop every driver without any individualized suspicion of wrongdoing, as long as the stop follows predetermined procedures. So the court, I'm not sure. Hopefully I don't get into some funny no man's land here. You guys can see me okay, right? Give me a 5x5. We're not buffering or anything, are we? Are we doing okay? Give me a 5x5. You guys can see me okay, because I'm... Friends in Code is here. What is going on? Can you guys see me all right? Just want to make sure you guys can see me okay. Can anybody hear me? Can anybody hear me? Give me a 5x5 if we're not buffering. Okay, cool. Yeah, Terry, the Fourth Amendment's been wiped away by Supreme Court holding after Supreme Court holding. So because I wasn't sure, I saw a buffering thing. I just wanted to make sure that you guys could see me okay and that we were still live. Okay, we still are. Yeah, it's absolutely. Thanks, you guys, for sticking around. I appreciate it. They're not going to promote the vertical stream no matter what I do. So I'm just going to do the best I can with Team DLZ and the people in the chat. So that's what I'm going to do. If you guys have any questions, feel free to let me know. And I have my phone right here in case one of the text messages comes in. So what Sitz versus Michigan State Police did was it created the idea that it was reasonable for police to stop you based on reasonable articulable suspicion that somebody on this road is driving drunk. And specifically what Sitz does is it takes away the individualized suspicion part of Terry versus Ohio and expands it to that we can be suspicious of anybody. Without the 1990 case of Sitz versus Michigan State Police, then you couldn't have stop and frisk in New York. Stop and frisk in New York is a direct reflection of the 1990 case of Michigan State Police versus Sitz. Without this case, stop and frisk wouldn't be legal in New York because Terry versus Ohio allows you to stop and frisk people based on individualized, articulable facts of suspicion of criminality. Sitz versus Michigan State Police takes it a step further and says, we don't have to have individualized suspicion of you. We can have general suspicion of everybody, and now we can stop and frisk you. Without Sitz versus Michigan State Police, you couldn't have stop and frisk in New York City. The holding. The court ruled that sobriety checkpoints are constitutional, allowing police to stop every driver without individualized suspicion, as long as they follow a predetermined set of procedures. This ideology was then extended into New York City, where they said, hey, we have a particular process we're using. We're not just stopping black people in the subways, which is exactly what they were doing. We're stopping people based on, we're following a procedure that everybody has to put their bag here and everybody has to be searched. Everybody's subjected to it. But it wasn't. It was done with racial profiling is what it was done. So what it did, Sitz destroyed the fundamental requirement that individualized suspicion by approving mass warrantless seizures and searches of citizens. It normalized the concept that police can stop every person without evidence of wrongdoing as long as they claim a compelling government interest. Sitz established that constitutional rights are negotiable when the state claims its public benefit, turning the Fourth Amendment from an individual protection into a collective privilege that the government can revoke at will. And this is the exact write-up. So I just want to be clear on that. Yep. Without Sitz, you don't have stop and frisk in New York City. Okay, so the next case is, so you guys have heard of Breonna Taylor. Breonna Taylor was murdered in her own home because of Terry versus Ohio extending into the 1995 case of Wilson versus Arkansas. And when I read you the story behind Wilson versus Arkansas, you're going to be able to say, holy snarl snake shit. How in the world is this even possible for this to be America? And remember, all of these cases happen right when black people are freed. Black people are not freed with 1954 Brown versus Board of Education. Black people are officially freed when the country has to be desegregated from the 1968 case of Green versus New Kent County. which I haven't gone into the details of it, but I will. 1995, Wilson versus Arkansas. Let me slide this bad chicken down a little bit here. Here. Okay. Almost there. Thanks for sticking with me. I appreciate it. Oh, you dirty son of a... Got that bad chicken. There we go. Okie dokie, pokey smoky. The 1995 case of Wilson versus Arkansas is exactly how Breonna Taylor was murdered in her own house, and the cops got away with it. Put a 1 in the chat if you're still with me. Put a 1 in the chat if you're still with me. Charlene Wilson was suspected of selling drugs from her home in Arkansas. Police obtained a search warrant, but were concerned that announcing their presence, using Kerr versus California knock and announce, that Wilson would have time to destroy the evidence, using the 1925 case of Carrol versus United States, where there's exigent circumstances that the contraband could be destroyed. They broke down her door without knocking or announcing themselves and found marijuana, methamphetamines, and drug paraphernalia. Charlene Wilson argued that the failure to knock and announce violated her Fourth Amendment right, claiming common law requirement that for the search to be constitutional, they at least have to knock and announce. The holding. The court ruled that the knock and announce principle is part of the Fourth Amendment's reasonableness, but created a massive exception, allowing police to skip the knocking if they claim the evidence could be destroyed or officer safety could be jeopardized. Terry versus Ohio, again, is rearing its ugly head in Wilson versus Arkansas in 1995. So what it did to the Fourth Amendment, Charlene Wilson, was what you would call a constitutional theater. It appeared to strengthen home protections while it actually created a checklist of excuses why police could break down your door immediately without knocking and announcing or even saying that you're there. The decision gave police pre-approved justification to bypass the knock and announce rule from Kerr, claiming that knocking and announcing could be a danger for officer safety, invoking Terry versus Ohio. Wilson turned home invasions into a procedure where police announce themselves while already breaking into your house, making the supposed protection meaningless while providing legal cover for warrantless entries of your house. So now go back to Breonna Taylor. The police went to her door, didn't knock, didn't announce, kicked her door open. When they kicked her door open, Breonna Taylor's boyfriend grabbed his firearm and started shooting because he didn't know, because they didn't knock and they didn't announce. Then the cops shot back into Breonna Taylor's house, claiming that for officer safety, they couldn't knock, they couldn't announce. Remember, Breonna Taylor was murdered and nobody was ever brought to justice. Hank, what's his name? Hank, whatever his name is, he was never, ever brought to justice. And it's all because of the 1995 case of Wilson versus Arkansas. Without Wilson versus Arkansas, then you wouldn't be able to just go into someone's home. And just so you know, after Wilson versus Arkansas, we had like 25,000 no-knock raids in America in the early 1990s, 1990, 1991, 1992. After Wilson versus Arkansas in 1995, we now have 250,000 no knock and announce, no knock raids because of the 1995 case of Wilson versus Arkansas. Why in the world can police go to your door, kick it down, and enter your house without a warrant, without announcing themselves? Because of the 1968 case of Terry versus Ohio, based on officer safety. They claim, using Brinegar, that a prudent man with the facts available to him as head at that time creates probable cause to believe, using Brinegar versus United States 1949. Kerr versus California, knock and announce rule. Well, we're going to jump ahead to 1968, Terry versus Ohio, and say that in the name of officer safety, if we knock and announce, they're going to go grab an AK-47 and start shooting at us. We believe that using our objective reasonableness standard from the 1989 case of Graham versus Connor. that says, I believe objectively that these guys have an AK-47 in there and they're going to shoot me. So the amount of force that I can use is dependent on my perspective of walking up to Breonna Taylor's house and not knocking on her door, just kicking it open. Well, when they kick the door open, in the name of officer safety, they then can start shooting. These things I'm telling you are 100% true. Yeah, Pennsylvania, eye for eye, news free press. I'm sorry, I don't have Pennsylvania versus Mims on this particular chart, but I'll cover Pennsylvania versus Mims for you. Pennsylvania versus Mims, the 1977 holding, is an extension of Terry versus Ohio. Harry Mims is pulled over in Pennsylvania. The cop claims that he saw a bulge in his pants and then ordered him out of the car. They found a gun on him. It went to the Supreme Court because Harry Mims was searched without a warrant and ordered out of his car without a warrant. And so when it goes to the Supreme Court then says, based on officer safety, you have to get out of the car upon being ordered out of the car. And a lot of people have it a little bit incorrect, as I had it incorrect until and there's some things I've been incorrect about in the past couple years that I'll clear up as we go over each and every one of these cases on the wall. But the simple truth is that Pennsylvania versus Mims was created in the name of racism. It was created so that the cops could grab black people and pull them out of their cars because Harry Mims was black. And I hate to say it. I mean, don't blame me. Don't be mad, my conservative friends who don't like to hear that everything's about race. We lost our rights based on prohibition of alcohol, prohibition of drugs, and racism. Terry versus Ohio is racist. Pennsylvania versus Mims is racist. Wilson versus Arkansas is based on race. He was a black guy. The 1985 case of Tennessee versus Garner is based on race. He was a black kid. These are just the simple facts. I'm not going to lie so that people will like me. If you don't like me, join the crowd. There's a lot of people. I don't care. I'm going to tell the truth whether you like it or not. And that earns me a lot of hate. So be it. So be it. Remember, I got hoodies in stock. Make sure you guys hit me up. I'll put it out on the text message to a few people, but I don't want to leave these hoodies sitting here. I don't want to ship hoodies every day. I want to sell all of them and ship them all at once and be done with them so I can focus on teaching and not shipping hoodies. I'm looking forward to it, though. I can't wait to see you guys wearing the We Don't Stop hoodies. I cannot wait. Cannot wait. Okay, so now we get to some of the most tyrannical stuff there ever has been. So Wren versus United States, 1996, 1 year after Wilson versus Arkansas. Let me read it so that I don't, in any way, shape, or form, make any sort of mistakes. So once again, Wren versus United States is a case based on racism. Michael Wren was a black guy. So let me see here. Michael Wren and James Brown were sitting in a truck stop in a high drug area. And remember, anything high drug area is going to be a poor community or a brown community of Washington, D.C., what seemed for like an unusually long time, when plainclothes officers in an unmarked car approached them. Wren turned suddenly, sped off, and ran a red light. And that's the whole key, that he ran a red light. The officers pulled them over for the traffic violation, but their real purpose was a drug investigation. During the stop, they saw bags of crack cocaine in Michael Wren's hands. Wren argued that it was a pretextual stop. The officers weren't really concerned about traffic safety. They were conducting a drug investigation using traffic laws as an excuse, and he was correct. The court ruled that police can use any traffic violation as a pretext stop for unrelated investigations that they're really interested in doing. As long as they observe an actual traffic violations, the officer's subjective intent or real motivation is irrelevant. So, in other words, they can just make up that we're seeing this in Duncan, Oklahoma, where they're pulling people over for crossing the imaginary white line at the stop sign that's not there. Or they're saying you didn't use a blinker 100 feet prior. And they turn the dash cams to face them instead of outwards, is what they've done in Duncan, Oklahoma. What it did to the Fourth Amendment. Michael Wren's case in Wren versus United States, 1996, legalized pretextual policing and destroyed requirements that stops be related to their stated purpose. It gave police unlimited power to use minor traffic violations as fishing expeditions for unrelated crimes. Since virtually every driver commits some minor traffic violation, Wren essentially eliminated the Fourth Amendment protection for anyone driving a car, allowing police to stop any vehicle they want by simply following it until the driver makes a minor traffic mistake. And then it turns traffic laws into a tool of general law enforcement rather than for public safety. And I've been trying to explain this to people this past week. And they're like, oh, well, he broke the law, Chille. Well, our entire Constitution and Bill of Rights is based on three Enlightenment thinkers: John Locke, Jean-Jacques Rousseau, and Charles de Montesquieu. Those three Enlightenment thinkers created the U.S. Constitution through their teachings, and then James Madison and Thomas Jefferson, they then solidified those ideas and put them into the U.S. Constitution. Montesquieu's book, written in 1750, translated into English in 1751, called Spirit of Laws, what it outlined is that the spirit of the law, the reason the law was created, is more important than the letter of the law. Spirit of the law, letter of the law. Well, if you say that, hey, you went over the line at the stop sign, pull him over, dude, that's the letter of the law. The spirit of the law is that there's nobody around, you're not hurting anybody, you're not pulling somebody over for public safety, you're pulling someone over because over the line, dude, mark it 0. And because of this letter of the law ideology within police today, because they could find a reason to pull you over at any time, day or night, then they will. Well, Wren versus United States, what that does is it turns you driving into a crime immediately. You can't drive anywhere in any small town in America at 2 o'clock in the morning and go to 7-Eleven, get a pint of ice cream without the cop using Wren to say, oh, you didn't signal 100 feet prior. And then the cop can make a mistake and you did signal 100 feet prior, but his perception of it was that you didn't. Using Heen versus North Carolina, 2014, he can then say, I pulled him over and I made a reasonable mistake of law. I'm not a human radar detector. I can't tell you if it was 100 feet or 200 feet or 50 feet. So I pulled him over thinking he didn't use his blinker 100 feet prior, invoking Wren. But now they want to pull you over, pull you out of the car using Pennsylvania versus Mims. Now they want to search your car. And now you got to sit on the side of the road for 30 minutes because the cop asked you where you're coming and where you're going. You said, I'm coming from my home over on 123 Main Street. Where are you heading? I'm heading up to Speedway on 1467 Pennsylvania. And the cop says, well, that little strip of traffic right there, that I could create a drug courier profile on you. My training and experience tells me at 2 o'clock in the morning, traveling from here to there. Now I'm going to call a drug dog out. And you say, well, right here in my trifold, it says the 2018 case of Rodriguez versus United States says that you can't extend a traffic stop without reasonable articulable suspicion. Well, you gave him the reasonable articulable suspicion when you told him where you're coming from and where you're going. Rodriguez versus United States. Do you see how the cases, when used together, absolutely decimate freedom in this country? Absolute decimate freedom. They decimate it. And just wait till you guys hear the First Amendment jurisprudence that I'll teach tomorrow. And wait till you guys hear the Fifth Amendment jurisprudence that I'll teach the next day. The Supreme Court has worked against us since the very beginning. So Wren versus United States is one of those cases that they can just make up. They can just make it up. You didn't use your blinker 100 feet prior. And then the judge says, well, we got to go Atwater here. Nope, we got to go Atwater. It's Atwater versus City of Lago Vista. It's the 2001 case. Let me slide down a little bit. This will be good in vertical form when I cut this down to vertical and then I just loop it. A lot of people are going to learn a lot. And so if you guys learn anything, go to my website and buy one of my trifolds. Get this trifold in your car. Invoke your Fifth Amendment right. You can get it on DeleteLawz.com with a Z. I say it's 1 for 20. I always give you 2 for 20. If you buy 2, I give you 3. So go to DeleteLawz.com and get a trifold. Invoke your Fifth Amendment right. Because if you tell the cop where you're coming and where you're going from, he's going to invoke Socolow and say he has a drug courier profile on you. And then once he has a drug courier profile on you, then he's going to search your car. And you got to sit on the side of the road, maybe in torture cuffs because you've been detained. The 2009 case of Arizona versus Johnson says that if you're the passenger in the car and the cop claims that I didn't use my blinker 100 feet prior, well, if you're the passenger in my car, now the cop could put you in torture cuffs using the 2009 case of Arizona versus Johnson or the 1997 case of Maryland versus Wilson. You guys, this is the reason why I do this trifold. This is the reason why I tell you, don't talk to cops. And after the Heather Chandler case, where we heard that dirty cop, Darius McReynolds, say, I'm going to go ask her some questions and get her talking. Ask her if she used to live in this place, if she knows where her insurance is. Derek McReynolds wanted Heather Chandler to talk so he could then claim, oh, I smell alcohol in your breath. Whereas if Heather Chandler had said, I invoke the fifth, and then not said another word and just pointed, then he may not have been able to say that she smelled like alcohol. She got a fake DUI. It's not real. It's fake. Darius, you're a scumbag, dude. Sorry about that. Anyway. And as the world turns, we continue. Good to see everybody, you guys. Good to see you. Put Team DLZ in the chat. Put Team DLZ in the chat. So this is going to extend us to the 2001 case of Atwater versus City of Lago Vista. So it was already bad enough. Good to see you guys. Thanks for sticking with me. I really appreciate it. So as we continue down the line, the 2001 case of Atwater versus City of Lago Vista, I know this case inside and out. I've taught it several times. But just so that people will listen to the information and take it in, I have the exact holding up on the screen here. I'm just going to read it, okay? That way there's going to be no mistake and people can say, oh, Chille's giving a slanted version. No, I'm not. I know Atwater versus City of Lago Vista inside and out. I've taught it for years. So on March 26, 1997, Gail Atwater was driving her pickup truck with her 3-year-old and her 5-year-old in Lago Vista, Texas. Officer Brett Turek, who had previously warned Atwater about her seatbelt violation, spotted her driving without seatbelts on her or her children. Under Texas law, this was a misdemeanor punishable by a $50 fine. No jail time was authorized. Despite the minor nature of the offense, Turek decided to arrest Gail Atwater right there on the side of the road. He approached her car and began yelling at her, calling her a bad mother, and told her she was going to jail. Atwater asked a friend to take her frightened children to a nearby friend's house, but Turek refused. Instead, he handcuffed Atwater in front of her children, placed her in a squad car, and drove her to the police station where she was booked. Had her mugshot taken, and was placed in a jail cell for about an hour until she could post bond. The Supreme Court ruled that the Fourth Amendment does not prohibit warrantless arrests for minor criminal offenses, even when the crime is punishable only by a fine and no jail time is authorized by state law. The exact holding says, written by David Souter in a 5-4 decision, Atwater versus City of Lago Vista, what it says is that if a peace officer sees you violate the law, even a minor infraction of the law, that is an arrestable offense and it is not a violation of your Fourth Amendment right. So we have all these cases here where the cops can enter into your life. Carrol versus United States, they don't need a warrant. Brinegar versus United States, they just need probable cause in their mind. It doesn't have to be real. 1968 Terry versus Ohio, I have reasonable articulable suspicion. Not even a crime, I'm just suspicious. 1983 Illinois versus Gates, totality of circumstances. I took all these individual pieces and now I've got reasonable suspicion. Jump all the way up to 2001 from the 1983 case of Illinois versus Gates. Reasonable suspicion is whatever I can put the facts together and then I can arrest you on even a minor infraction of the law. I'm suspicious you didn't have your seatbelt on, so that's arrestable now. Which is just, when we talk about Atwater versus City of Lago Vista, when we have OTVO, and that's what this team is, and you guys know about Terry versus Ohio, but Atwater versus City of Lago Vista is particularly disturbing. Let me read what it does. Obliterated proportionality. It eliminated any connection between the severity of the offense and the government response, allowing maximum force for minimum violations. A maximum force is you being kidnapped off the street and taken to a dungeon. It created arrest power for any violation. Police gained authority to arrest, handcuff, transport, book, and jail citizens for infractions like littering, jaywalking, or not wearing a seatbelt. Third, it triggered full search powers. Since Robinson, 1973, that we talked about, allows full searches incident to arrest, Atwater meant police could now conduct complete searches for any minor violation that they could arrest you for. It destroyed family protection. It authorized separating parents from children and traumatizing families over trivial infractions. Fifth, it made every citizen vulnerable. Since everyone commits a minor violation daily, and you guys have seen this before, 5 felonies a day, I think it's called. Atwater made every American subject to arrest, and the full criminal procedure, the full apparatus of the criminal justice system could come down on you at any time because your dog shit on the side of the road and you didn't clean it up. Well, that's an infraction of the law. Or your dog wasn't on a leash. Or let's say that you're the passenger in the car and you weren't wearing a seatbelt, manual mata. And what they do to Manuel Mata when they said he wasn't wearing a seatbelt? They arrested him and took him to a dungeon for simply not wearing a seatbelt. The exact same case of Gail Atwater, only this time Manuel Mata was sitting in the passenger seat. It eliminated the officer discretion requirement. It gave police unlimited power to choose between arresting you or giving you a ticket. Remember, Atwater versus City of Lago Vista, whether or not you will be arrested is 100% up to the officer's discretion. So when you hear a cop say, oh, I ran it in, but, I'm sorry, we're on camera, I have to arrest you, that's a lie. That's an absolute, total, complete, and utter lie. Charlie Harrington, good to see you, Charlie. Thanks for coming by. Charlie said, again, case law is not law. Charlie, respectfully, I'm going to disagree with you and agree with you. Terry versus Ohio is a policy, but Charlie, can you be subjected to the Terry versus Ohio policy? And if Supreme Court case law is not law, then explain to me how Atwater versus City of Lago Vista, if you don't have your dog on a leash, that you can be arrested for that, Charlie. Explain that to me, brother. If it's not law, well, then I can't be arrested for not wearing my seatbelt. Now, what you can do to overturn Atwater versus City of Lago Vista, and I'm going to put these bills right on DeleteLawz.com. You can download them. I just need to know who wants a bill for their state. I'm going to write the bill for your state in Connecticut that says you can only be arrested if you're a danger to yourself or a danger to society. I'll write that bill for Connecticut. But what I need is you, that person who lives in Connecticut, to say, I'm going to take the bill that Chille wrote using AI, and I'm going to get that into my House of Representatives. I'm going to get it into committee for House of Representatives, and then I'm going to get it to pass committee by campaigning for it, getting it maybe a citizens referendum, then get it to the full legislature of the Connecticut state legislature, and then get that bill passed that would wipe out Atwater versus City of Lago Vista. You could do the exact same thing in Texas. You could do the exact same thing in Alaska. You could absolutely wipe away Atwater versus City of Lago Vista in your state by getting a bill into the House committee, getting it to the larger committee, then getting it to the entire House, to the entire Congress of your state. Ohio would be a good one. I see that, Nick Tate. Ohio would be a good one. Ohio, they fought so hard to get the referendum to abolish qualified immunity in Ohio, and then your piece of garbage attorney general, I think his name is Yosh. Is it Dave Yosh, or is that the governor? And then they tried to wipe it off, and then the court said you can't take away a citizen's referendum. Okay, let's keep going. And then the next case in Atwater, OTVO all. You know it. You know it. So now we're going to move on to the 2003 case of Maryland versus Pringle. 2003 case of Maryland versus Pringle. It's here. Okay, so I don't have to move this bad chicken. I can just stand on the other side here. There we go. Remember, I got hoodies in. Let's get these hoodies. I spent $30 on the hoodie. It cost me $30 for the hoodie plus the print. I sell them for $50, so I make $20. The shipping is $13, so it's $63. If you want to do $65, then I make $22. But I want to get these hoodies shipped out. I don't want to be shipping hoodies all week long. Hopefully I can just do one batch. It's going to take all week. It'll take all week. But thanks for buying my stuff from me. I appreciate it if you guys get a hoodie. Okay, so Maryland versus Pringle, the 2003 case. Maryland versus Pringle, of course, is an extension of Terry versus Ohio. Terry versus Ohio is, of course, an extension of Carrol versus United States, 1925. Every case I've listed here today, besides Graham versus Connor, has been an extension of Terry versus Ohio. There hasn't been a single case I've talked about, aside from Graham versus Connor, that is not an extension and only possible because of Terry versus Ohio. Maryland versus Pringle. Here. At 3:16 a.m. on August 6, 1999, Baltimore County Police Officer John McKee stopped a Nissan Maxima for speeding on Route 95. The car contained 3 men. Demetrius Pringle in the front passenger seat, Otis Smith driving, and Jerome Smith in the back seat. Officer McKee asked and received consent to search the vehicle. It's in your trifold. Do not consent unless you're going to give consent and then revoke it. During the search, he found $763 in cash rolled up in the glove compartment and 5 bags of cocaine hidden behind the back seat slot. When none of the 3 men claimed ownership of the drugs or money, McKee arrested all 3 of the men for possession of cocaine with intent to distribute. Demetrius Pringle argued that there was no probable cause to arrest him, specifically because the drugs weren't found on his person. He wasn't the owner of the car. He was sitting in the passenger seat, and he had no idea that there was contraband in the car. Contraband is typically evidence, illegal evidence. The holding. The court ruled that when drugs or contraband are found in a car, police have probable cause to believe, Brinegar, 1949, probable cause to believe comes from Brinegar. If they find contraband in the car, police have probable cause to believe that all the occupants possess the contraband, allowing the arrest of everyone in the car, regardless of individualized suspicion. Sitz versus Michigan State Police, 1990, extended now into Maryland. Sitz is only possible because of Terry versus Ohio. So now what does it do? Pringle destroyed the individual accountability and created guilt by association. And this is the policing factor that they use constantly now. And so what happens is when you eliminate individual probable cause, it removed the requirement that police have to have specific evidence against you. It created collective guilt. Being present when contraband is found makes you automatically guilty regardless of your actual knowledge or involvement. It made proximity to a crime an offense. Your physical location near any sort of illegal item is now evidence of your guilt because of the 2003 case of Maryland versus Pringle. It destroyed the presumption of innocence. Remember, you're presumed innocent until found guilty. Instead of requiring proof of individualized guilt, it presumed every person around the contraband is guilty of that contraband. It encouraged mass arrests. Police can now arrest entire groups of people based on one person having contraband. You're driving down the street in a van. You got 6 people in the van. The van gets pulled over. Whoever's got the contraband pulls it out of their pocket and throws it under the seat. All 6 people in the van now are guilty. And they're not presumed innocent. They're presumed guilty. 2003 case of Maryland versus Pringle completely turns the presumption of innocent until proven guilty to guilty until you prove yourself innocent or until somebody in the car claims the contraband. It eliminated the right to association. Being with the wrong people at the wrong time now makes you a criminal, chilling freedom of association. Pringle essentially made presence of a crime equal to possession and turned being in the wrong place into the crime itself. Remember, all of these cases all hinge off one another. The only way Maryland versus Pringle is possible is if you have Brinegar versus United States 1949. You pull over 6 people in a van, I have probable cause to believe that all of you knew about the contraband. Without Brinegar, you don't get Pringle. Sooner or later, we're going to have to make some changes here. We're going to have to overturn these cases on a state-by-state basis. I will write the bill for your state, whatever state you live in. I'll write the bill for you. I'll put it on my website. You can download it. I'm going to use AI to write the bill to overturn Maryland versus Pringle where you live, where you have to have individualized suspicion to arrest people in the car. You can't just say, well, I'm suspicious that everybody in the car knew about the contraband. Which laws are you subjected to? Federal laws or state laws? State laws. Does the state constitution trump federal laws? It absolutely does. If the state constitution says that you have to have probable cause to arrest everybody in the car, then the federal Supreme Court holding doesn't matter. It only matters if the federal law is created, a law, not a policy, back to what Charlie said. In this case, Charlie, you would be correct that the policy of the Supreme Court is not law. So if you passed in Connecticut that you have to have probable cause to arrest everybody in the car for finding contraband, and that was a statute, code, ordinance, or part of the Connecticut state constitution, then this policy of the Supreme Court would be wiped away, would be null and void. But if the feds passed a law that said that you got pulled over, everybody in the car is now guilty by association, then that federal law from the Baltimore versus Barron 1853 year of Baltimore versus Barron 1833. God dang it. Sorry about that. So, okay. So you could pass a bill in Connecticut that would wipe away Maryland versus Pringle, wipe away Brinegar versus United States, wipe away Terry versus Ohio in your state. You know where Pennsylvania versus Mims is not applicable? In the state of Pennsylvania. The state of Pennsylvania, the Pennsylvania State Supreme Court said that you can't order someone out of the car in the name of officer safety. You don't have to get out of the car in Pennsylvania. But the rest of us do because of the Supreme Court holding. Now, in the state of Alaska, if you got a bill passed that said you don't have to step out of the car in the name of officer safety, then that policy by the Supreme Court in Pennsylvania versus Mims would be null and void. Let's keep going. There's just so many cases. I don't want to make a mistake because I want to cut this into a vertical. Okay. I believe the next case is going to be the 2009 case. I believe the next case is going to be 2014 case of Heen versus North Carolina. And if you don't know the case of Heen, when you get Maryland versus Pringle, Utah versus Streiff, and Heen versus North Carolina, those three cases, I'll tie them together for you in a moment. But first, you have to understand Heen versus North Carolina. You have to understand Utah versus Streiff. You understand Maryland versus Pringle, right? Put a 1 in the chat if you understand Maryland versus Pringle. If you do. I picked up the hoodies today. Team DLZ on the back. I spent $30 on the hoodie, 13 for the hoodie, 17 for the print, and then I sell them for $50 plus $13 shipping and handling. It cost me $12.95 to ship them, and I ship them priority mail, so they're there in 2 days or 3 days at the most. So I got hoodies in. Hit me up if you guys want one. I got large, extra large, double XL, and triple XL. I have those 4 sizes in, so hit me up, and let's keep going. Oh, shit. Let's slide us down a little bit here so we can get everything in. What happened? Okay, we back? Okay, sorry about that. I lost sight for a second here. Hey, Justin Barnes. Heen versus North Carolina. Okay, right here. Let me get this bad chicken dialed in. I'm sure you did not get a notification. I'm positive of that. And by the way, guys, if you guys have any cases like Justin Barnes, thanks for the super chat, man. First one of the day. God bless you, brother. I appreciate the support. So, but someone just said in here, Falcon Man, Chambers versus Florida is great. I'll be happy to cover any cases. I just have to have time to research them because all of these cases I know off the top of my head, but I'm just reading it. That way I can't make any mistakes. One time I made a mistake between Johnson versus McIntosh and another case, and someone made a video saying how I was this big moron. I literally had just switched the files in my mind, but when you're doing a lot of cases, it's easy to do. So that's what I had done, and that someone made a video about me saying what a moron I was, and I was like, I obviously I made a mistake. Didn't mean to. Don't tell anybody I'm not perfect. Don't tell anybody. Don't dispel the rumor. Okay, so the 2014 case of Heen versus North Carolina. Often you'll see something happen. Everybody will see a case happen on the screen, and they'll say, "Oh man, that's an easy lawsuit. They're going to win that lawsuit so easily," but they don't know the case, the 2014 case of Heen versus North Carolina. Heen versus North Carolina. What it does is it gives another layer of blanket immunity for police. And I think that it's going to also track under the good faith exception I think it's going to track under the good faith exception, which is going to start with the 1984 case of Leon versus United States. 1984 case of Leon, where they create the good faith exception where the police can arrest you. Or is that the attenuation doctrine? I'll stay in my lane here. You see what I mean? There's so many cases that you can easily get yourself. Mark Woodward with a super chat, buddy. Thank you, man. I appreciate it. So the 2014 case of Heen, if on the screen what mattered was the size of the case, Heen versus North Carolina would be this big. This case, while it's a tiny little case on the wall, it is one of the most fundamentally unconstitutional garbage cases that you've ever heard. Let me read the exact breakdown of Heen, just so I don't make any mistakes here. In 2009, Sergeant Matt Darcy pulled over Nicholas Hine in his car because one of the brake lights wasn't working. Under North Carolina at the time, vehicles were only required to have one working brake light. I'm sure the legislature changed that to 2 after this case, of course. During the traffic stop, Darius became suspicious after he pulled him over for only having one tail light, but he only needed one. And so Heen said, "F you, I only have to have one traffic light." So during the stop, then Sergeant Matt Darius decides to search the car. And when they searched the car, it revealed a sandwich bag full of cocaine, leading to Heen's arrest. Heen argued that since the officer was wrong about the law, there was no actual violation. The stop would be unconstitutional. Before 2014, that was true. The holding. The Supreme Court ruled that police officers can make reasonable mistakes of law and still conduct constitutional stop and searches. If an officer's misunderstanding of the law is reasonable, any evidence obtained is still admissible. Now, remind me to come back to Weeks and Silverthorne, and I will. So make sure you guys remind me to come back to explain Weeks and Silverthorne, but I want to finish this one first. So what it did to the Fourth Amendment, Heen is absolutely tyrannical because it eliminated the requirement the police actually know the law they're enforcing. It created several devastating precedences that you have to be aware of. It legalized police ignorance. Officers no longer need to correctly understand laws they enforce. Ignorance of the law became a valid excuse for constitutional violations. In other words, in Duncan, Oklahoma, I didn't think you used your blinker 100 feet prior. You look at the dash cam or the body cam, clearly they used their blinker 100 feet prior. Well, now that cop is allowed to make a reasonable mistake of law. Then he looks in your car, you have an open container that has this much alcohol in the back of the trunk, and boom, now you're going to jail for an open container. It destroyed legal certainty. Citizens now can be stopped and searched based on laws that don't actually exist, as long as the officer made a reasonable mistake of the law. So in other words, they could say that you have to have a light above your review mirror or above your driver's side mirror. They can just make up that they believed that you had to have a light right there on your driver's side mirror. They pull you over and say, "Hey, I didn't see a light on your driver's side mirror." And you say, "What the hell are you talking about? I don't need a light on my driver's side mirror." He goes, "No, I think you do." Then the cop decides to look in your car, sees this much of the bottle of an alcohol, and then he arrests you for having an open container in your car. So he can just make up things. They can just make up new laws that don't exist. It created asymmetrical justice. While ignoring ignorance of the law is no excuse, still applies to you and me as citizens, police are now excused for not knowing the law that they arrest you for. It expanded pretextual stops. Remember we talked about Wren versus United States 1996? Police can now claim they reasonably misunderstood any law to justify an otherwise illegal stop. It made law enforcement above the law. That's what this case did. Heen versus North Carolina, it put law enforcement above the law. It gave police powers to violate rights based on their misunderstanding, while citizens are held to they have to understand the exact legal precedent. Heen essentially said police don't have to know the law correctly to violate your constitutional rights, making legal ignorance a tool of your oppression. So Heen versus North Carolina, it turned justice upside down, because justice is when the peace officer is enforcing a law that is meant for public safety, but instead it's used to oppress you and to put a police state on top of you. And that's what Heen versus North Carolina actually does. This means that police can make a reasonable mistake of law anytime they want. They can say, oh, I thought you had to be in the far right lane to take that right turn, when really it was a double lane. So you could turn from the left lane, or you could turn from the right lane. And the cop says, well, you know, you have to be in the far right lane to take a right. Even though there's two lanes turned to the right, the cop can say, well, I thought that you had to be in the closest right lane. They could just make it up. It's a bad example because it's a bad holding. Now, what could you do in Connecticut? What could you do in Ohio? You could overturn Heen versus North Carolina with a bill that I'll put on my website. Just let me know where you live and I'll write the bill for you. Heen versus North Carolina. And let's take a recap of what Heen versus North Carolina actually means in the grand scheme of things. So going back to Carrol versus United States, where there can be warrantless searches of your car, we extend that into Brinegar versus United States, 1949. Probable cause exists in the minds of the officer when he has probable cause to believe that you've committed a crime. So you pull out of your driveway and you're driving down the road, and the cop, when you pull out, says, oh, I thought I saw that car at the trap house the other day, that exact same red Ford. Well, there's a lot of red Fords, but the cop is sure that your red Ford was the car that he saw at that drug house. So now probable cause exists in the mind of a prudent man who has probable cause to believe. Brinegar. Now the cop wants to stop you using the 1968 case of Terry versus Ohio, reasonable suspicion, extended into the 1996 case of Wren that creates pretextual stops. He's going to now say, I thought you had to be in the right lane to turn right. I didn't know there was a double right lane. He pulls you over. He finds this much weed in the bottom of a bag, and now you're going to jail. But he didn't have any proof. He didn't have any probable cause. He had probable cause to believe in his mind. And that's Brinegar plus Terry. Then he pretextually stopped you on a bogus traffic stop because he made a reasonable mistake of the law using Heen versus North Carolina. Now you get pulled over. You got three people in the car. One of your buddies had a bag of weed, threw it under the seat. Now all three of you are going to jail because he has probable cause to believe in his mind. And Maryland versus Pringle justifies that if they find contraband in your car and nobody claims it, that you're all three guilty. When you really know this stuff, oh man, you can tell. You can tell. Coming to the end. Coming to the end. Hold on. Just a couple more cases. I'm coming up on about an hour, I guess, because I'm running out of juice. The old cord. Okay, there we go. Thanks. Pig Hunters in the chat. What's going on? Thanks you guys for coming. Make sure you hit the like button. Put Team DLZ in the chat. Put Team DLZ in the chat if you would, please. And remember, this is just a bigger profile. I'm going to put this in vertical, and I'm going to loop it and stream it over and over and over. It's 4:19. You got a minute. Got 1 minute, huh? It's 2:35 here. John Lunn, I got the hoodies in. I sent you an email, John Lunn. Check your email. Check your email. Okay. Okay. So now let's go to we only have 3 cases to go. We only have three cases. I think we have 3 cases to go, and that's going to include Boyd County, which is a circuit court case that was appealed to the Supreme Court and kicked back down by Justice Sonia Sotomayor. And so now we're going to go into now here's where things get absolutely tyrannical, beyond the pale of what you could possibly even understand. here, can you see that on the board? Okay, you guys can see it. So the 2016 case of Utah versus Strieff uses the exact same principles of Maryland versus Pringle, that you're guilty until you can prove yourself innocent. And what Utah versus Strieff specifically does is it gives police another layer of blanket immunity that works against liberty, against freedom, and for the police state, prison state, death state. And any cop who uses Utah versus Strieff, you could just classify them as an absolute pig, because they didn't take an oath to uphold the Constitution. They took an oath to join a police state, prison state, death state. Utah versus Strieff, I have already written the bill for the state of California to overturn Utah versus Strieff here, but let me read you the story so that way I don't make any mistakes. In 2006, someone, now we go back to Adams versus Williams, 1972, where an anonymous source, we don't know who it was, we don't have to investigate it, Adams versus Williams says that the police can take a tip over the phone, and now that's reasonable articulable suspicion from the 1968 case of Terry versus Ohio. In Utah versus Strieff, someone called the police with an anonymous tip about drug activity at a South Salt Lake City house. Detective Robert Frackle conducted an intermittent surveillance and saw people making brief stops to the house. Behavior he thought was consistent with drug dealing. After watching for about a week, Frackle saw Edward Strieff leave the house and decided to stop him for investigative purposes. Even though he had no reasonable suspicion that Strieff personally had done anything wrong, during the stop, Frackle discovered that Strieff had an outstanding warrant for a minor traffic violation. This gave Frackle authority to arrest Strieff, and during the search incident to arrest, 1973, Robinson versus United States, he found methamphetamines and drug paraphernalia. The Supreme Court holding. The Supreme Court ruled that evidence obtained during an illegal stop can still be used in court if the police discover an outstanding warrant for your arrest. Because the warrant purges the taint or cleanses the taint of the stop, the original constitutional violation is then cleansed because you had a warrant for your arrest. It's so fucked up. It's so unbelievable. So what it did to the Fourth Amendment, Strieff was the final nail in the Fourth Amendment coffin. This was the last straw as far as you having a Fourth Amendment, because it's wiped away clean after Utah versus Strieff. Legalized illegal stops. Police can now stop anyone illegally, knowing that if they find a warrant, all the evidence that they find becomes admissible. It created the attenuation doctrine. It established that constitutional violations can be cleansed by discovering an unrelated legal justification after the fact. So if you have a warrant and they stop you unconstitutionally, well, the fact that they found a warrant now makes their stop constitutional. Riddle me that. I can riddle you that. That's a conservative right-wing Supreme Court. I used to tell you guys that I identified as a conservative. I do not. I do not identify with a conservative Supreme Court justice at all whatsoever. They take our rights and give them to the police. It's horrific. This incentivized fishing expeditions. Officers are now rewarded for illegal stops because any warrant discovery validates their constitutional violation. It made warrants weapons. Outstanding warrants, often for minor traffic infractions, become tools to transform illegal police misconduct into legal searches. It destroyed deterrent effect for the police. The exclusionary rule that was created in the 1914 case of Weeks versus United States expanded into the 1920 case of Silverthorne Lumber Company, which created Fruit of the Poisonous Tree. It completely wipes that away because the exclusionary rule is gutted because police violations are no longer relevant if they find a simple suppressed warrant that they didn't know you had. Now, they could run your car and say that whoever owns that car has a warrant, 2020 case of Kansas versus Glover, and then they could pull you over based on the idea that the person driving the car also has a warrant. Now, let me be clear. The 2020 case of Kansas versus Glover is about when they run your license plate using a plate reader, and it says that the person who has the car either has a suspended, revoked, or expired driver's license. They can then extrapolate that with probable cause to believe, using Brinegar 1949, that the person driving the car doesn't have the driver's license. Once again, you're guilty until you prove yourself innocent, that I'm Jose, I'm not Tim, who's owner of this car. But now you still have to be subjected to the police state. This encouraged warrant mills. It incentivized jurisdictions to issue warrants for minor violations to give police more tools for constitutional violations. You understand? So in other words, where you may not have gotten a warrant before for not using a blinker or your dog was off the leash, now municipalities, boroughs, districts, they now are incentivized to make sure they issue that warrant so that if the police stop you, they can then search you. And if they find any sort of contraband, whether it's on you or not, if they pull you over, everybody in the car has been detained. If your passenger has been detained and he pulls out a bag and throws it under the seat, and then they pull you over unconstitutionally, claiming that whoever owns this car doesn't have a valid license, well, that would be a constitutional stop according to Kansas versus Glover. If they pull the car over and there's no traffic violation, and then they find that you have a warrant, well, then it's a perfectly constitutional stop. If they pull you over and they find contraband under the seat, and then you don't claim that contraband using Maryland versus Pringle, they can arrest you and arrest the passenger. So this is, it's just, and by the way, the next case is the 2020 case of Kansas versus Glover. So let me read that to you. The 2020 case, and we're also going to get into, was it Boyd? List out Wisconsin case of Boyd County. So reasonable articulable suspicion is really going to expand in Brown versus Polk County 2020. It's a 7th Circuit case. But the number 20 case is Kansas versus Glover. Deputy Mark Murr was on patrol in Lawrence, Kansas when he ran a license plate check on a Chevy pickup truck. The computer database showed the registered owner, Charles Glover, had a revoked driver's license. Deputy Murr had no visual confirmation of who was actually driving the car. He couldn't see if the driver was Glover or somebody else. Based solely on the assumption that the registered owner was Glover, Officer Murr pulled him over. It turned out that Glover was indeed the driver, and he was arrested for driving on a revoked license. The holding from the Supreme Court. The Supreme Court ruled that police officers have reasonable suspicion to stop a vehicle, Terry versus Ohio, when the license plate check reveals that the registered owner has a suspended or revoked license, even without any evidence that the owner is actually driving the car. So if your license is suspended or revoked or expired and you loan your car to somebody else, you have to make sure that you tell them, I have a suspended license. The cops are probably going to pull you over in the assumption that it's me. Once again, flipping the burden of proof of innocent until proven guilty to guilty until proven innocent. So if you have a revoked or a suspended driver's license, your car is now marked by these flock cameras all over the country. And people in the chat know about this. There it is right there. So what it did to the Fourth Amendment, it legalized assumption-based stops. Police can now stop vehicles based purely on the statistical probability that you're the driver rather than evidence of any wrongdoing of a traffic infraction. It eliminated visual confirmation requirement. Remember, Murr couldn't see Glover in the car. Officers no longer need to see who's driving the car or have evidence that the owner is behind the wheel. I could borrow a car from Sarah McLaughlin, and then when I'm driving the car, clearly I'm a man. They could pull me over anyway and say, oh, I thought you were Sarah. I don't look like a Sarah. It created database reasonable suspicion. Computer records alone became sufficient justification for stops without any real-world evidence that there's probable cause. Made registration a liability. Simply having your name on a vehicle registration makes you subject to being stopped even when you're not driving. It automated constitutional violations. It enabled algorithm-based policing where computers generate reasonable suspicion without any human observation. And this destroyed the individual assessment analysis. Police can bypass looking at actual driver behavior and instead rely on bureaucratic record and assumptions. Kansas versus Glover essentially made vehicle ownership suspicious and turned license plate databases into a tools for automated constitutional violations based purely on speculation. And it's so unbelievable. It's so unbelievable. Good to see you guys. Put Team DLZ in the chat. Put Team DLZ in the chat. I can't wait to strip this into a vertical format and then just let it loop live so that thousands of people will be able to see how we lost our Fourth Amendment. And this is how we did it. So I got one more case. We're going to do two. We're going to do the Felix case as well. So how far will the court take the whole idea of reasonable suspicion and inject it into your life where it becomes absolutely tyrannical? I think I have it here. I have it under, here's Kansas versus Glover 2020. Do I have Polk County on here? Let me see. I don't know if I have it on the wall, but I'm going to read it to you guys anyway. I don't have it on there. It's not there. But let me read you the case. It's Brown versus Polk County 2020 out of the 7th Circuit. And you guys have to know this. If you've learned about Terry versus Ohio and reasonable articulable suspicion, but if you don't know about Brown versus Polk County, let me tell you how far they'll take reasonable articulable suspicion. This was a Wisconsin cavity search case. You heard that right. A Wisconsin cavity search case where a detainee at the Polk County Jail underwent physical searches of her body cavity based on reports from fellow inmates that she was concealing drugs inside of her body cavity. The 7th Circuit ruled that the search was constitutional based on what? Terry versus Ohio reasonable articulable suspicion, expanded into the 1983 case of Illinois versus Gates, where they took the totality of the circumstances. They have an inmate in the jail. Other inmates are saying that she has drugs inside of her cavity, so we have reasonable articulable suspicion. Reasonable articulable suspicion equals that they get to search you. In this case, they searched, her name was, it doesn't have her name on here. What was her name? Let me give you her full name so you guys actually understand here. Brown versus Polk County, it just refers to Brown. I think her name was, I want to say Mary Brown or something like that, but she was a black woman. And what they did is they then searched her cavity, and it left her in an absolute shamble. They searched her front cavity and they searched her back cavity, and it was a male officer that did the search on Brown based on reasonable articulable suspicion, based on probable cause believes in the mind's officer. Probable cause exists where a prudent man believes that a criminal activity is afoot. Extended in the 1983 case of Illinois versus Gates, the totality of circumstances. And then we get all the way here to the 2020 case of Brown versus Polk County, and they're doing a cavity search both front and back. That's how far they'll take reasonable articulable suspicion. Remember, the 1972 case of Adams versus Williams says they can take a tip from a confidential informant and they don't have to investigate the confidential informant. They used to because of the 1969 case of Aguilar Spinelli, but that was wiped away with the 1983 case of Illinois versus Gates. So all you have to do is call the police and tell them that this person is this or that, and then the police will ruin that person's life. It absolutely has to change. I'm pretty sure that the next case, Life Under the Microscope, is here. Right on, my friend. Good to see you. I already got that one. One second. Bear with me here real quick. Yeah, Barnes versus Felix. So now, if you guys are... So now, we really should have covered the 2009 case of Arizona versus Gant. We should have covered the 1969 case of Chille. We should have covered the 1981 case of New York versus Belton. There's cases that you have to know, but this is just the basic introduction to these cases so that you guys can really understand Fourth Amendment jurisprudence. And I'm going to teach this every single day. Every day that I'm in this studio, I'm going to teach this. Remember that I have hoodies in, and I would like to get rid of them. I would like to sell them. I want to see you guys wearing the merch. So let's get into it. So now we have the 2025 case of Barnes versus Felix. Now, this case is a check on the 1989 case of Graham versus Connor, where they had the objective reasonableness standard and cops could make split-second decisions based on officer safety from the 1968 case of Terry versus Ohio. But Barnes versus Felix, let me give you the story. In Houston, Texas, Deputy Constable Robert Felix pulled over 24-year-old Ashton Barnes for suspected unpaid tolls, which, by the way, Dallas has sent me tickets and said I have an unpaid toll that I didn't even know if it was real or not. A minor traffic violation are unpaid tolls. During the traffic stop, Felix claimed to smell marijuana, although no drugs were found, and ordered Barnes to exit the vehicle. When Barnes began to drive away instead, Felix made a split-second decision to jump on the moving car's door. While clinging to the outside of the vehicle for approximately 2 seconds, Felix fired 2 shots through the window, fatally killing Barnes. Barnes managed to stop the car before dying. The entire incident, from the car seated moving to when it stopped, lasted 5 seconds. The holding. The Supreme Court unanimously rejected the Fifth Circuit's moment of threat doctrine, ruling that courts must consider the totality of circumstances. Now, Illinois versus Gates, totality of circumstances, 1981 Cortez versus United States, now becomes a relevant thing where you're taking the totality of circumstances and finally spinning it around and making the cops accountable to the totality of circumstances. The Supreme Court unanimously rejected the Fifth Circuit's moment of threat doctrine, ruling that courts must consider the totality of circumstances when evaluating excessive force claims, not just the final moments when an officer claims that their life was in danger. Barnes versus Felix was a rare pushback against police immunity, but it operated within a fundamentally broken Graham versus Connor framework. Graham versus Connor, objective reasonableness, force must be judged from the perspective of the reasonable officer on the scene. That's a flawed and broken ideology, and it was created by William Rehnquist. William Rehnquist was the biggest copsucker piece of garbage Supreme Court justice, maybe going all the way back to the very beginning, the very beginning to Stephen Fields. Stephen Fields was one of the biggest piece of trash Supreme Court justice that we had really seen in a long time. But even Stephen Field had some sort of integrity in his holdings. The way that he ruled was truly based on a conservative ideology, whereas William Rehnquist was 100% based on racism and totalitarianism and authoritarianism. William Rehnquist, I swear to you, I'm trying to keep this PG-13. I wish him the worst. I wish him the worst. If there's life after death, I hope that he is hot, that he's very hot right now. I'll put it like that. And I've done a good job on this. No curse words. I really want children to be able to watch this, to be able to learn what I'm teaching here. So what it did to the Fourth Amendment, it was a pushback against police immunity, but it's still done in the lens of Graham versus Connor. So it did three things. It rejected time-limited analysis. It eliminated the moment of threat rule that only looked at the final seconds of a police encounter. So now we're no longer living in the final seconds, it's the whole thing. It restored totalitarian standards from Cortez versus United States and Illinois versus Gates 1981 and 1983. Courts must now consider all events leading up to the use of force, not just the climactical moment of the murder. It questioned officer-created danger. Often police will be the ones who create this exigent circumstances situation where the person wants to run or there could be a loss of life because the officer has escalated the situation. So this question, the officer created danger, while not directly addressing it, the decision opened the door to examining how officers create danger situations. The limitations. It still uses the Graham versus Connor analysis. It maintained the objectively reasonable officer test that heavily favors police. It didn't address the root problems. It failed to eliminate qualified immunity or the reasonable officer fiction. So it used a very narrow scope. It only addressed timing of analysis, not the fundamental bias towards police in excessive force cases. Barnes was a small crack in police immunity, but left the overall system of constitutional destruction intact, showing that even victories operate within a framework designed to protect police rather than citizens. So now that is 22 cases starting in 1925 and ending in 2025. We have 2 or 3 good cases that work in our favor. It would be, well, Arizona versus Gantt 2009, which I did not cover. But what it does is Arizona versus Gantt pushes back on the 1981 case of New York versus Belton, essentially overruling New York versus. I don't think it's safe for me to sit here and go over cases that I haven't taught you yet. So I think that I should just not. I'll add these cases when I teach the attenuation doctrine and the good faith exception over the next couple days, because I'm going to continue to teach like this. For those of you guys waiting on my board game, I have a big announcement for you coming up in the next few days. Stick with me for 1 second. I'll get back to you guys. So then the last thing is hoodies. $50 plus $13 shipping and handling. You could pay $15 if you want. It doesn't matter. It's going to be between $13 and $15. I make $20. I buy the hoodie for $13, print it for $17, and then I make $20 on each hoodie. And I've got about 3 dozen hoodies in, ranging from large, extra large, double XL, and triple XL. So there it is right there. There it is right there. That's what I have going. That's what I've got going over here. Dar, good to see you. Fred Wagner is here. Rancho Relaxo. Maxim Manuelian is in the chat. Good to see you, man. Oh, man, someone got deleted. I'm sorry to see that. John Lunn is here. John, did you check your email? Omega Red is here. Goofy Jester, Kevin Bernarski. And then let me thank a couple of people, because a couple of people sent me super chats through my website, which I really appreciate. Thank you very much. And that's Joseph K. And that's and that would be also. Are we on page 1 here? Yes, we are. I appreciate that. Thank you so much. John W., thank you for your John W. and Joseph K. John W. and Joseph K. Thank you guys so much for donating, and I really appreciate that. And somebody else did as well on Cash App. So I want to say thank you to that person as well. Dan Hanlon, I got your donation. Thank you so much. I really appreciate it. I promise you guys this. I won't stop if you don't stop. I will not stop if you guys don't stop under any. Bruce, I got you. Bruce, and I got you also Death Angel. So Death Angel and Bruce, I got you Bruce for your double XL, and I got you Death Angel for your triple XL. Right on. Got you, man. Got you. And then Matthew D. Thank you so much, Matthew D., for your contribution. I really appreciate it. Right on. Kyle Hamilton, loved the channel. I watch daily. I'm about to do a cop audit in my town. Everyone else is scared to. Right on, Kyle. I really appreciate that. Right on. Let's OTVO. Let's OTVO. What's up, my brother? How are you? Let me check that Let's OTVO and see if we can reach out to that guy over there in Arizona. Let me see if I can get that Let's OTVO. I'll tell you right now. Not yet. Not yet, Let's OTVO. Still waiting. Hasn't got there yet, but it will. Let's OTVO. Love you, buddy. You don't stop, dude. Let's OTVO. You don't stop. I've met a lot of people in my lifetime who give up, that stop, that quit, that don't want to fight, that it gets too hard, gets too stressful. They'll find an excuse. Oh, my wife. Oh, my dog. Oh, my bad heart. Oh, my liver. But not Let's OTVO. That guy doesn't stop. There's few people in this world who I know will not stop. And Let's OTVO is one of those guys. And we don't stop. We are not going to stop. Wait, I'm holding back, you guys. I'm holding back. There's things I want to say, but I can't say them yet. But there are things. Shaniqua, what is going on? Maxim Mawilian, Maxim, you have got a great civil rights lawsuit. I wish I could help you. I'm just not sure who's writing your federal civil rights lawsuit. And I don't want to get prosecuted because they'll try to arrest me for anything that I do. It's plain as day they've targeted. Danelle Brown, good to see you. Mama Lion, Raw Weber. Hoodies are in, you guys. Hoodies are in. I've got 4. I have 4 triple XL. One of them is gone. I have 3 triple XL left. I've got 3 extra large. I've got 3 larges. So that's what I have. 3 large, 3 XL, 3 triple XL. Double XL, I have a dozen. So make sure you guys hit me up for those hoodies. Make sure you guys hit me up for Mama Lion. Hey, good to see you, Mama Lion. I'm glad you could be here. Thank you for coming. Thank you for coming. Yeah, I've got limited quantities of these. It's just a money thing. I want to get the hats too, but I need another like $600 to do the hats. So I'm just going to keep pushing forward. I did not see my man Chevy. I did not see Chevy. Chevy, are you hiding back there? Mr. Dixon, what's going on, my friend? How are you? Mr. Dixon, I got it. I'm going to do the hats, I promise. I'm just building up here. I'm just building up. I'm going to teach this every day. I'm going to do a new lecture every day on the history of case law and how the cases tie together. I'm going to read the actual holding and then give you my perspective and show you how the cases come together. And that's what I'm going to do. It's 3 o'clock now. I've got a, James, I'm not doing, you just hit me up with PayPal, Venmo, or Cash App, and it's $63. So let me know. You can shoot me an email, James Forbes. I think I have your phone number in here. So yeah. Lodi, California. I would love to, man. Me too. Me too. Okay, listen, I'm sweating because I'm in the corner of my studio that doesn't get any AC. And so I am sweating my ass off here. But I wanted to thank Mr. Dixon. Thank you. Joseph K. and John W. Thank you guys for your contributions. I super appreciate it. Thank you so much. I cannot do anything without you guys. I need to sell more trifolds. I've got trifolds in stock. So if you haven't got a trifold for your brother, your cousin, your sister, your lover, make sure you get a trifold. I have it on the website as $20 plus $2 shipping. I always give 2 on every single order. If you order 2, I give you 3. So make sure you guys have it in there. You are so welcome, Lisa Burt. Thanks for the super chat. Thanks for sharing the knowledge you have with us. You are so welcome. So, all right, let me get the flock out of here. Lisa Burt, I really appreciate that super chat. Thanks a lot. Thanks a lot. I'm going to have to do a vertical stream just to get my numbers up. I hate doing vertical streams, but I'm going to have to do a vertical stream. Maybe I'll edit this down and then I'll stream this live and it'll be as though it's a live vertical stream. I'll do that. I'll do that. All right, listen, I'm going to get the flock out of here. Thanks for coming to my TED Talk. Wanda Meese, I'm glad you're out. John Lund, check your email and get back to me.